close the machine and ascertain the result. On that question, there were 98 ayes, 0 nays, and 2 members absent, 2/3 of members having voted in the affirmative. The chair declares that bill effective from passage. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4191, relating to requirements imposed on social media companies to prevent corruption and provide transparency of election-related content made available on social media websites.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman, 22nd to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to modify the requirements imposed on social media companies to prevent corruption and to provide transparency of election-related content made available on social media websites. This bill creates the Social Media Integrity and Anti-Corruption in Elections Act. It sets forth findings, defines terms, provides requirements for social media companies to prevent corruption and provide transparency of that election-related content made available on those social media websites. It provides for filing of a campaign finance report or material if certain actions are undertaken, and provides equal opportunities for all candidates and political parties to speak without policy or partisan-based censorship. It prohibits modifying visibility of election information based on type of content, provides due process requirements for restriction of access to social media platforms, it provides civil penalties, and it provides rulemaking authority. Mr. Speaker, we derive our ability to govern from the consent of the governed, and I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Gentleman from the 79th, Second Hansen is recognized.
Thank you, Mr. Speaker. Would the gentleman yield for a question?
Yes.
What responsibilities, are there any new responsibilities imposed on the West Virginia Secretary of State's office?
There are. So the Secretary of State would be tasked with working with, and by the way, this bill comes in consultation with the Secretary of State, with working with between 60 days from any primary, general, or special statewide or federal election and the date the election is certified to make sure that a social media platform ensures the accuracy of published election content, which includes official dates or deadlines such as election dates, early voting periods and deadlines, voters' registration requirements, processes, or procedures, in-person or absentee ballot voting requirements, processes, or procedures, get out the vote or GOTV information, polling place locations or hours, voter identification requirements, security and integrity of elections, instructions for receiving, completing, or submitting a ballot, and information about any candidate on a ballot. I'm sorry.
How does the Secretary of State's office ensure the accuracy of those things? Is it before they're published or after they're published by the social media platform?
The intent is for that to be before they're published. To give you a little bit of background to the gentleman with a little bit of leeway, in the 2020 election, Facebook actually put out inaccurate primary election dates and deadlines to register to vote. And so that was put out for a period of time, and the Secretary of State had a very difficult time in working with these entities to have that taken down and corrected.
Is there a rulemaking process included in this bill so that the companies know what procedure to go through to get their posts pre-approved?
Yes, there is rulemaking provided for in the bill.
Okay, but it is the intention that within 60 days of the election, social media platforms can't publish any of that information without pre-approval from the Secretary of State. Is that right?
Yes, that is accurate.
Okay, and then I also wanted to ask you about other similar laws in Texas and in Florida. Could you explain where those are?
I'm sorry, can I explain the other states' laws, or can I explain the differences with this and their laws? I'm not following.
Fair question. To be more explicit, my understanding is that Texas and Florida have passed similar laws, and those are currently pending before the United States Supreme Court.
Certainly. So there's a significant difference in that as it relates to Section 230 of the Communications Decency Act of 1996, which is the subject of those Supreme Court challenges. This bill seeks to clarify that that amplification or de-amplification of messaging from any candidate or political party is actually an in-kind contribution to the campaign, and Section 230 of the Communications Decency Act has never been held to invalidate campaign finance law.
So are those two bills in the other two states, do they have similar provisions about pre-approval from the state, West Virginia Secretary of State?
No, I do not believe so. Forgive me, I've not studied those other states' bills. The bill before us is what is before us.
Okay, thank you for yielding. My understanding of those Supreme Court cases is that they're currently pending before the United States Supreme Court. A decision is expected soon, which would give us greater guidance as to what would be constitutional or unconstitutional in the state of West Virginia, and it would be wise to wait for that decision. I do have some specific concerns about the substantive issue that I asked questions about requiring these companies to get pre-approval from the Secretary of State's office before they could print even basic information about dates of elections and things like that. I'm concerned that that could impact voter turnout. I think we want as much information as possible out to voters to make sure they know about elections and can participate in the process. So for that reason, I'm a no vote on this bill.
Question still before the House is, shall the bill pass? Is there other debate on the bill? Gentleman from the 52nd, Douglas Rose, recognized.
Thank you, Mr. Speaker. Would the gentleman answer a few more questions?
Yes.
Do they have to guarantee truth on their platforms?
So are you asking that in the context of a user posting content or the company itself posting content?
Well, the company itself is what I'm thinking.
That is the exact purpose for checking with the Secretary of State. And in the example that I gave from the 2020 election, Meta unfortunately posted untrue content.
Okay. Is there any prior restraint? Does the Secretary of State have the right to review and restrain information before it's published?
I believe that would be provided for in rulemaking, but the bill does require that they check with the Secretary of State, the Chief Elections Officer of the state.
Now, what happens if they make a mistake?
Council advises mistakes are correctable, but they would still have to check with. It would be unlawful, quite frankly, for them to choose not to check with the Secretary of State in advance of doing that for all information 60 days before an election or at the certification.
But if they did make a mistake, they would be liable for civil but not criminal penalties?
Yes, it would not be a criminal penalty. I believe that the Secretary of State and/or Attorney General, who both have rulemaking in the bill, could seek injunctive relief.
Is there any federal government agency or regulatory body that would be involved in this as well?
Not that I'm aware of. The bill does have legislative findings in it comparing what we're seeking to do here with other holdings for instance, the Federal Communications Commission in regards to television and print media advertising.
Now, may I inquire about individuals who post election material? Is there any penalty on their not being truthful?
No.
Is there any prior restraint by the Secretary of State's office for individuals putting up campaign material?
No, there's not. And to perhaps add some additional clarity there, the only thing that would be targeted at a user's post would generally be that of a campaign or a candidate or a political party. And if that candidate, campaign, or political party were either denied access or their message or post was amplified or de-amplified.
So this wouldn't alter standard litigation possibilities for slander, would it, against an individual that put up false information?
It would not.
All right. And there's nothing in the bill that would create an opportunity to bring an action to the Secretary of State or to anyone else in regard to slander?
It would not.
Okay. And help me, you did answer, I asked the question and I heard you say it, but I'm not sure I got it right. If they make a mistake, do they have an opportunity to fix it within a certain time period? The media company.
So they may make a mistake. They may or may not be subject to a civil penalty as may be provided in rulemaking as counsel is advising me. In addition to that, there could be injunctive relief and things of that nature if they were to do so.
But I'm trying to inquire, let's say mistakes happen. Let's say they make a mistake and they call the Secretary of State's office and says, look, we goofed this and we're putting it up that we got it wrong as to the date of the election, or I don't know what misinformation it might be, would they be able to skirt civil penalties if they fix it in a reasonable period of time?
Council advises that would be up to the Secretary of State, who would generally be able to waive such a penalty.
The Secretary of State would be able to waive?
Yes, the Chief Elections Officer of the state is the enforcement on this.
Thank you, sir. Thank you, Mr. Speaker.
Gentleman 54th, Douglas Pushkin is recognized.
Thank you, Mr. Speaker. Would the gentleman continue to yield?
Yes.
Thank you. I'm confused by this subsection E on page 3, requiring social media platforms to provide a campaign finance report to the Secretary of State. Does this take place in any other state where we require?
I believe this is our novel approach, and,
I'm sorry,
and
what?
this is our novel approach, as I understand it.
Okay, I got you. So no other state does this?
That's my understanding.
Okay. I'm just trying to figure out how this would work, because I would see them more as a vendor, and vendors don't normally put, it's up to the candidate to file the report. Say, I just did a paid ad on Facebook or whatever, and then that would go in the candidate's report. Not the vendor filing a report, a vendor that isn't located in West Virginia filing a report. I don't understand how that would work.
Certainly. So I'll answer that in a number of ways. First, in what I would call an analog rather than a digital way. So to make this an analog rather than a digital way, right? So let's take this out of the internet for a second. If Mike excuse me, I'm not supposed to speak to the gentleman's name. I apologize. If the gentleman owned a billboard company, right, and one of your colleagues, let's say me, right, and you wanted to see me win re-election, and you ordinarily charge for a billboard, right? That has some traditional value which you ordinarily set. And if you decided to put out a billboard for my campaign, that would be an in-kind contribution to my campaign, would it not? Okay. So similarly, with digital ads or placements or organic posts being either amplified or de-amplified, that action by that company is an in-kind contribution. Again, the same as having taken out a billboard for a candidate. Correct. Or if you were to purchase one billboard and then instead you were given 5, as a for instance, right? So that disparate treatment of candidates in a race, right, would bestow value. And that value, which we don't have to place on it, they do, they sell ads, right? Then would have to be reported. Their ad revenues are based upon impressions, interactions, click-throughs. Of course, I know the gentleman is aware of that. But so that is the instance in which that would spawn a campaign finance report.
Okay, so say I have a campaign Facebook page, right?
Yes.
And I just do a regular post. I don't boost it. It's an organic post. But for some reason, the biorhythm causes that to be seen by more people than normal. I don't know how that works. I'm not going to begin to pretend that I know how that works. They would have to report that more people viewed this page.
If via their algorithms or their action it caused that. So rather than ordinarily, so somebody shares your post, that sort of thing, that just happens, right? But if they were tinkering with the algorithm, or let me give you another example. If you were shadow banned, if for some reason you were not allowed to, your posts were artificially diminished, right? That is a detriment to you and a benefit to your competitor.
Okay. I'm still not real clear on this. I hope everybody else is. I don't know how this would work. I really don't. I guess I'll phrase this in the form of a question. So would this apply to, say a platform like Truth Social? Say a certain presidential candidate gets more hits. They're going to have to file with the Secretary of State saying, well, this particular presidential candidate's getting more views on Truth Social.
If via the algorithm or intervention therein they cause that. So let me give you an example since you point out Truth Social. If President Trump were on there and President Biden were on there, let's say they had the exact same number of followers, and organically, if no tinkering were going on, they both put out a post, they should generally get the same number of views. If they then went in instead and tinkered with that and diminished one over the other, the answer to that is yes.
Okay. All right. Thank you for yielding. I'm still possibly more confused than when I first stood up, Mr. Speaker. I don't know how they could possibly report on this, but.
Gentleman to 42nd, Doug Steele.
Thank you, Mr. Speaker. Good morning, everyone, or afternoon, as it were. I just wanted to go through and point out a couple things in the bill. The title has to do with social media platforms, which I think traditionally most of us would think of Twitter and Facebook. I guess it's not called Twitter anymore, but nonetheless, if I look in here, social media platform on page 2 means a user-specific web-based technology intended to create virtual connection through the internet, which includes any online information service provider, internet search engine, access software provider, internet website, or application that enables users within the state of West Virginia to create, publish, and view content online at no cost to the user. So this would also include online news platforms that do not charge a subscription. So, there's that. This would include someone's blog, like if you had your own blog spot or something like that, and maybe you had your own personal political opinion about, hey, I don't like that bald delegate that doesn't like libraries, and they write something about that, on their blog, and it's within 60 days of an election, all of a sudden, something has to get reported by this blogger to the Secretary of State. Now, I want to point out something with campaign finance reports. All of us in here have some connection with filling out a campaign finance report. I fill them out as a candidate, but as someone who has a media company and sells advertising, I can tell you that the advertiser never fills out a campaign finance report. There is no capacity for an advertiser to send a report in to the Secretary of State. Now, if we got a request from the Secretary of State of, some type of audit of a candidate's, contributions or expenditures, and they wanted to confirm, were you in fact paid this amount of money for this set of advertising? Yes, we would lawfully respond to that kind of subpoena from the Secretary of State. But what we're attempting to do is put a burden upon really a non-domestic company. I can't imagine too many of these social media platforms are based in West Virginia. What I think that it will eventually do is it will cause those folks to black out West Virginia. And all of a sudden, we lose a valuable form of communication with one another of how to get out our political ideas, about how we feel about particular issues. Now, the other thing that goes along with this is we talked about the algorithm. We talk about how does somebody get to the top? How does somebody get a little bit of an advantage? I think most of us in here who have been in politics for a while understand that gaining followers on Facebook and gaining followers on Twitter is something that is largely done organically right now. Now, there's potential that sometimes that, social media companies have been called in front of Congress and whatnot to answer questions about, how did this particular your thing go down? But I know on a local level, the way you gain followers and appear higher in the algorithm is by posting more content and reaching out to people and getting your message out there more and interacting with people more, which is exactly what you're supposed to be doing if you're campaigning, right? So what we're going to do is put a burden on a foreign company, foreign to West Virginia. I'm not saying like an alien company outside of the United States, but largely foreign companies, based outside the state of West Virginia. We're going to put a burden on them to report something to the Secretary of State that any normal advertiser would not have to report on. Well, they're just simply going to cut West Virginia off. That's all that's going to happen. I mean, the rest of the United States is just going to look at us and be like, okay, you guys have fun over there with your paper mailers, have a good time. And they're going to cut us off from one of the most valuable tools we have to reach out to our constituents, whether that be folks that agree with me or don't agree with me. I mean, we get it all the time. So I look down through here and, you know, I see some things put on companies, and I'm not saying I'm a big fan of Facebook or X or whoever else is out there, or Truth Social or whatever blog is running out there. I have no idea. I'm not saying that I'm here to defend them. What I am here to defend is their constitutional right to publish information. I mean, the First Amendment was intended at its very inception to protect political speech. Now, I mean, there's some proponents of this bill that I would grant. They do have a couple points that have some of these companies been called in front of Congress for potentially favoring one side over another. Absolutely. But I think any media outlet in America could be called in front of Congress, or thankfully we can't do that here in this legislature. I have a feeling we do it far too often. But I have a feeling that any media outlet can be accused of bias. But when we start limiting speech like this, we're going to put an effect on some of these platforms where they will say, you know what, West Virginia, y'all have fun. And now our people are going to lose the ability to gain information, to evaluate it. I trust the public. I trust the public to read whatever story they're reading, to read whatever post they're reading, and ingest that and decide for themselves, is this believable or is it not believable? But I think what we have here, while it could be intended to solve a problem, I don't really see the problem at the moment. I think it goes to a point of impacting what we swore to defend. And that is the right of my opposition to vocally and publicly disagree with me, and do it loudly, and do it in a manner that might even hurt my feelings. And that is just fine, because that's what America is all about. And we start talking about some of these election bills right here, and there's one thing that I would say. Federally, on the federal level, an advertiser cannot turn away advertising on a federal level. On a state level, with state election law, we can turn away advertising we don't want. And this would turn an online advertiser into a position of being forced into advertising something they may not want to advertise, whereas if they were a traditional media outlet, like a print-only media outlet, they wouldn't have that problem. But an online advertiser would all of a sudden be forced into this, if that makes sense. So I think you have First Amendment problems, I think you have equal protection problems, I think you have Commerce Clause problems, but what the problem I don't think you have is I don't see how the bad conduct that we're worried about in this bill at the end of the day affects any of our constituents or any of the people in here, because I think we all need to just accept the fact that people are going to disagree with us, and it's okay. It's okay for them to disagree. So I'd urge rejection of the bill.
Question still is, shall the bill pass? Is there other debate on the bill? Is there other debate on the bill? Gentleman from the 93rd District, Hornby is recognized.
Thank you, Mr. Speaker. After the conversations that we've heard, I too rise against this bill as an owner of a media company. I think it really doesn't stipulate who, why, how. So I have to say, under the first, I think it violates the First Amendment. I agree with the gentleman from Raleigh.
Is there other debate on the bill? Lady from the 4th District, Winson-Reed.
Apologies, I think a page may have hit my button.
Is there other debate on the bill? If not, gentleman, 22nd, District Linville, to close debate on the bill.
Thank you, Mr. Speaker. So this body has actually passed a more robust form of this bill previously. Of note, I listened intently to the gentleman and his remarks, and I'd like to perhaps go into some of this. So the definitions that the gentleman began to go into that he would claim or assert would begin to impact various media companies in the state, or if you have a news aggregation website, or you have the ability to have someone that posts comments on a story, I do not believe meet the definition here. Neither does the Secretary of State's office also. This is a bill that's been worked on for more than 4 years, and it's designed to narrowly be tailored to those companies which have users interacting constantly with users, right? And so that being truly social media companies. Again, I would point even to the short title of the bill, social media companies, not just media companies. That adjective matters. That adjective matters. It is not simply those companies that put out the news or a radio station or something like that. Not at all. Not at all. To the gentleman who just spoke, my friend, who went into concerns relative to, as an owner of a media company, the FCC already regulates your industry, right? And those regulations, as I understand them, state that you have to take advertising from all political candidates, and that you must offer them the same rate and airtime as their opposition. Nothing in this bill would modify that in the least. Nothing in this bill would modify that in the least. What this bill is solving, to the gentleman from, forgive me, I can't recall if it's the 41st or 42nd points, is to actually make sure that you can be criticized. It cuts both ways, right? Doesn't matter if you're a Republican or a Democrat. Does not matter. You would have the ability as a candidate or a political party to post. You would not be shadow banned, or your opposition would not have their posts be artificially inflated. Be artificially inflated. And friends, let me tell you, we know. What problem are we trying to solve? Read the Twitter files. After Elon Musk bought the company, he put them out. He showed your federal government seeking to take down particular posts. He showed your federal government engaging in an effort during elections, during the COVID-19 pandemic, and all other sorts of things to suppress political speech, and to do so working with then Twitter. Now, since then, X, as it's now known, has put forward their entire algorithm. They've open sourced it. You can look at it. You can see exactly how a post is dealt with. The other companies have not. The other companies have not. Friends, as I look through this, this is an endeavor to both respect the Constitution, respect the Supremacy Clause as well in Section 230 of the Communications Decency Act. And we went very carefully into that and the types of items, even if put forward by a candidate, as contemplated in this bill, that can be removed. Now, we have seen the most major political candidates in this country removed from these platforms. There is a sitting state senator in the state of West Virginia who for weeks has had his opponent be able to run ads on Facebook, and he has not. And he has not. That's happening right now. They're denying that individual the ability to speak on that platform. Friends, free and fair elections matter. We derive our ability to govern from the consent of the governed. We've endeavored to do this in a way that is clear, convincing, and concise. And as for me, I stand with the President, President Trump. I urge passage.
Debate on the bill has been closed. For what purpose does the lady from the fourth Thurgood Winds and Reed seek recognition?
Thank you, Mr. Speaker. As previously discussed, a ruling on House Rule 49.
Certainly. As relayed to the chair, those set of facts represented by the lady from the fourth Thurgood Winds and Reed would constitute a class of greater than 5 individuals, and therefore you are eligible to vote. Gentleman, the 42nd, Douglas Steele.
Same request.
Ladies and gentlemen, at this time, the clerk will please prepare the machine for all members who wish to record a request for a ruling pursuant to House Rule 49 on this bill. Please press your button at this time to seek a ruling by the chair under House Rule 49. Thank you. Clerk will please note those members seeking a ruling under House Rule 49. Ladies and gentlemen, it is a ruling of the chair that there are in the room greater than 5 individuals who constitute a class of greater than 5. Therefore, all members are eligible to vote on this question. Question now before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 61 ayes, 35 nays, 4 members absent, a majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4191 relating to requirements imposed on social media companies to prevent corruption and provide transparency of election-related content made available on social media websites.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5031.
Lady from the 71st.
Excuse me. Thank you, Mr. Speaker. I ask unanimous consent to postpone action 1 day.
Lady from the 71st asked unanimous consent to postpone action 1 day on the bill. Are there objections? No objections are heard. Action will be postponed 1 day on the bill. Next bill on third reading.
Committee substitute for House Bill 5043 relating to requirements, prohibitions, and regulation of foreign principals or agents of foreign principals, lobbying by or on behalf of such foreign principals or their agents.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 51st, I guess fast to explain the bill.
Thank you, Mr. Speaker. This bill amends the code to essentially incorporate a West Virginia variant of the Federal Foreign Agent Registration Act of 1938. The bill amends current code to provide needed cross-references. It then establishes requirements for lobbyists to register if working on behalf of a foreign principal. It adds prohibitions and regulations of foreign principals or agents of foreign principals, and then establishes criminal liabilities and fines for violations of the requirements applicable to such foreign principals or agents. That is a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye, and those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 95 ayes, 0 nays, and 5 members absent, a majority of members having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5043 relating to requirements, prohibitions, and regulation of foreign principals or agents of foreign principals, lobbying by or on behalf of such foreign principals or their agents.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5180.
Lady from the 71st.
Thank you, Mr. Speaker. I ask unanimous consent to postpone action 1 day.
Are there objections to postponing action 1 day on the bill? No objections are heard, and action will be postponed 1 day on the bill. Next bill on third reading.
Committee substitute for House Bill 5235 to double the criminal penalty for anyone found guilty of sexual assault on a minor.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 8th, Kelly to explain the bill.
Thank you, Mr. Speaker. Good afternoon, everybody. The bill amends West Virginia Code to provide for increased penalties for sexual assault on a minor. The penalties are doubled. It also provides for penalties when a parent, custodian, or person in a position of trust who fails to report sexual assault or abuse of the child. That is a summary of the bill, Mr. Speaker.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Gentleman of 76, Garcia is recognized.
Thank you, Mr. Speaker. Will the Vice Chair yield for a few questions?
Yes.
So we took this bill up in Judiciary, and we had a prosecuting attorney, I believe from Jackson County, talked about some of the potential consequences of raising these penalties. Do you recall that?
You can refresh my memory, sir.
Sure. So one of the things I think I remember him saying, one of the potentially unintended consequences of raising all these criminal penalties, it really doubling them, is the fact that it's going to be harder for prosecutors who in many cases have plea agreements and don't take everything to trial, that it would be very unlikely that with these penalties someone would actually take a plea agreement. Do you recall that?
I do recall that.
Do you also recall kind of what that might mean for victims of crimes, of these types of crimes that we're doubling the penalties for?
Again, you can refresh my memory if you wish.
All right. So I recall him saying, so number one, if somebody is unwilling to take a plea and they're going to roll the dice on a trial, you have to prepare the victim. You have to have the victim testify and have to go through really the trauma of that situation all over again, and the possibility that they would lose, which can always happen at trial, and that somebody who maybe committed an act like this gets off. Do you recall that testimony?
I do recall that, yes.
So, I mean, would you agree with me? There were some concerns from prosecutors about raising it just double with every single criminal penalty.
I would agree with you that we heard from a single prosecutor, yes.
Okay, was he there representing, I think, the Prosecutors Association?
I am not aware if he was.
Okay.
I believe he may have been.
Very
But
good.
I can speak to my own experience as an investigator, if I may.
I would love that.
As an investigator, we're not seeing many plea bargains on these to begin with, even right now. And these have a tendency to drag on as it is now. So the intent is to increase these because people aren't entering pleas anyway to the gentleman's inquiry.
Okay.
From my experience as an investigator.
Okay. Very good. No more questions, but speak to the bill.
Gentleman is recognized for that purpose.
So, you know what? It's difficult when we have conversations that are on difficult issues like this, where we want to make sure that there is justice for victims. And certainly, in many instances, I think we could all agree that where somebody's been sentenced, it could absolutely be more, and it would be deserving. And I struggle with this, really, when I'm thinking about it. What is good policy? I think, again, often when you think of situations that tear at your heart for somebody that's been through this, you know, that doesn't mean that necessarily the policy that we're doing is good. And then, quite frankly, the politics of this it's terrible, really. I mean, who wants to vote against a bill that would potentially be weaker on somebody who's committed a crime of sexual violence, right? But I hesitate on something like this, as far as everything being raised double. And we've had lots of criminal penalties over the years that it seems like we never do a reorganization. Although I'll give credit to my friend from the 42nd, who for several years has tried to do a bill that would look at the whole criminal code and try to reorganize it in such a way where we're balancing different crimes against each other. But what we tend to do is just every penalty goes up. And in certain instances, that might be justified. I have some questions as far as whether this is the right way to go. I really don't know how I'm going to vote, but I think these questions should be asked. So, thank you, Mr. Speaker.
Gentleman, the 44th, Kirby.
Thank you, Mr. Speaker. I appreciate the concerns that were raised here today and also the concerns that were raised in the Judiciary Committee by the gentleman representing the Prosecuting Attorneys Association. However, I'm going to take a different perspective from this. The majority, or a large percentage of the cases that are tried in my district involve child sexual abuse. And the reason is the penalties are already extremely high, as well they should be. But if we are going to have the people that are victims of these horrible crimes come forward and express their story and tell their story to a jury and oftentimes an open courtroom, we should allow them to secure a sufficient penalty for the perpetrator. And so I think that I don't disagree that there may be some instances where this could keep a defendant from pleading guilty. Well, so be it. Let him come in and defend himself and let the victim tell the court and the jury exactly what happened. And when that happens, they should be rewarded with a stiff penalty of 40 years and a doubling of all the other penalties. So I'd like to thank the gentleman from Wyoming for bringing this bill to the floor. I think it's overdue, and I would urge adoption. And in closing, I would just say, while the stiffening of the penalties is definitely an important aspect of this bill, I think one of the greatest parts of the bill is now we are going to encompass criminal liability for any custodian or caretaker of a child that knows about sexual abuse towards a child and does not come forward. Thank you, Mr. Speaker.
Is there other debate on the bill? Gentleman from the 55th, Doggett Acres.
Thank you, Mr. Speaker. I just want to say that I agree that we are increasing the penalties for what we would call some of the worst criminal offenses and violent offenses. But speaking on behalf of the members of the Judiciary Committee and the rest of the members of this body who have voted in some of these other bills we've seen this year, we're also addressing some of the nonviolent offenses, and we are, for example, expunging certain crimes from people's background. So I think we have a good balance in this body of addressing the serious violent crimes, crimes against children, in which I think the penalties can't be strong enough, while we're also recognizing the rights of the people who have committed nonviolent offenses and trying to get them back into the workforce and productive. So this body is not simply trying to hammer everyone who commits a crime. We have a balance here. Thank you, Mr. Speaker.
Gentleman from the 13th, Doggett Heckert.
Thank you, Mr. Speaker. I keep hearing about we're raising penalties for this and for that, and most of them I agree with. This one I agree with because the children that go through this are scarred for life. Not 5 years, not 10 years. The people that do this awful, horrible deed to our children need to be punished at the maximum. There are cases where maybe it should be looked at, but that's what we got judges for. But they ought to have the ability to give them the maximum of what they can give them. I urge passage. Thank you.
Is there other debate on the bill? Gentleman from the 8th, to close debate on the bill.
Speaker, very briefly, I understand the arguments that we've heard today, but ladies and gentlemen, it boils down to this. When children are harmed, we have to step up and do something about it. We have to make a statement that if you live in West Virginia and you harm a child, we're going to see to it that we put you away for the longest period possible. We owe it to our children in West Virginia to protect them. We owe it to the court system. We owe it to every West Virginian to provide punishments for these terrible crimes that somewhat fit the crime. Thank you, sir.
Question now before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 98 ayes, 0 nays, 2 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 5235 to double the criminal penalty for anyone found guilty of sexual assault on a minor.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5395 relating to judicial review of board decisions.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman 51st to explain the bill.
Thank you, Mr. Speaker. This committee substitute clarifies that the Commissioner of the Bureau of Unemployment Programs is an interested party with the discretion to appear in appeals of a Board of Review decision. It repeals a statute that makes the Board of Review a necessary party in appeals of its decision and providing for counsel for such appeals. That's a summary, Mr. Speaker. I urge passage.
The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5395 relating to judicial review of board decisions.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5520 relating to juvenile competency.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 51st to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to clarify competency proceeding for juvenile delinquency court actions. The bill repeals the presumption of competence of a juvenile 14 years of age or older for purposes of juvenile delinquency proceedings. It repeals the presumption of incompetence of a juvenile under the age of 14 years for the purposes of juvenile delinquency proceedings, and it makes corrections to other sections of the article to remove references to such presumptions of competence or incompetence. That's a summary, Mr. Speaker. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Gentleman of 58th, your vote's not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there were 95 ayes, 1 nay, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
House Bill 5520 relating to juvenile competency.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5561 relating to permitting the electronic execution of trusts.
Are there objections to having this bill explained in lieu of having the bill read? If not, gentleman from 51st to explain the bill.
Thank you, Mr. Speaker. This bill amends West Virginia Code to provide that trusts can be created by information stored in an electronic medium. It also allows for the electronic signing of trust documents. That's a summary, Mr. Speaker. I urge passage.
The question before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 93 ayes, 0 nays, and 7 members absent. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5561 relating to permitting the electronic execution of trusts.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5569 requiring an appraiser to pay for a background check required by the AMC as a condition of being added to the AMC's panel of appraisers.
Are there objections to having this bill explained in lieu of having it read? No objections are heard. Gentleman 68 to explain the bill.
Thank you, Mr. Speaker. House Bill 5569 prohibits appraisal management companies from requiring appraisers being added to an appraisal management company's panel of appraisers pay for a background check required by the appraisal management company. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there were 94 ayes, 0 nays, and 6 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 5569 requiring an appraiser to pay for a background check required by the AMC as a condition of being added to the AMC's panel of appraisers.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5582 modifying exceptions for real estate appraisal licensure.
Are there objections to having this bill explained in lieu of having the bill read? If not, gentleman number 68 to explain the bill.
Thank you, Mr. Speaker. House Bill 5582 edits the exceptions to the requirement that a person who performs a real estate valuation appraisal be licensed under the terms of the chapter. The existing exemption for evaluating the value of real estate serving as collateral for a loan by a financial institution is clarified to apply to unlicensed individuals, and the evaluation is required to be on a form stating compliance with the section. The requirement of the loan value is changed to be less than or equal to the federal de minimis threshold, and the form is required to state that the evaluation was performed by an unlicensed individual. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Those in favor, is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 96 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 5582, modifying exceptions for real estate appraisal licensure.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5593, relating to the creation, composition, qualifications, and compensation of the State Board of Risk and Insurance Management.
Are there objections to having this bill explained in lieu of having the bill read? If not, gentleman from 68th to explain the bill.
Thank you, Mr. Speaker. House Bill 5593 would change the composition of the BRIM. The board would still consist of 5 members, one of whom is the Vice Chancellor of the HEPC. However, the remaining 4 slots would be filled by citizen members with at least 10 years of experience in the insurance industry. These 4 members shall be appointed by the governor, and 2 shall be appointed from 2 lists of 3 people each that are separately submitted to the governor by the President of the Senate and the Speaker of the House. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Gentleman from 52nd row is recognized.
Would the gentleman answer a few questions, please?
Certainly.
Now, we're not increasing the number of members of the board. It's going to be 5 now and 5 in the future.
Correct.
But now, does this, it looks like that the legislature is going to propose folks to the governor to pick, but the governor's basically going to be able to appoint all the members of the board that are citizen members. That's 4, not HEPC's chancellor.
Correct.
Okay. Is this proposed by the agency, by BRIM? Do you know?
I'm not sure if that was proposed by BRIM. I don't believe so.
Okay. And what do they do? Do they set rates for the agencies to pay each year for their premiums?
They're responsible for getting casualty insurance for state agencies.
So they buy that privately for the agencies. Is that right?
I'm sorry, could you repeat that?
Okay, I was trying to capsulize what you had said, that they make arrangements for insurance, casualty insurance with private companies.
Yes.
And does BRIM have liability for lawsuits that are filed against the state in regard to an agency or some public body?
Does BRIM itself have liability, or are they arranging for the coverage?
Right.
Yes, they're arranging for the coverage.
It was my understanding that BRIM charged each of the agencies and had a determination when there was a major payout that they would be deciding it. But you're saying no, that we use private insurance now, and BRIM does not make payments and does not have to approve large payouts. Is that right? Oh.
Yes, BRIM is arranging the policy, but they're not directly providing it.
So they don't make decisions about liability settlements for an agency. The private insurance company does that only?
I believe they are involved in the negotiations on the settlement.
Okay. What happens to the money that the agencies have associated in the budget for BRIM? Does it go to BRIM and then they work with the insurance companies?
I'm not certain. That's a little outside the boundaries of the bill.
All right, thank you, sir.
Thank you.
Question again before the House is, shall the bill pass? Is there debate on the bill? Does the gentleman wish to close debate on the bill? If not, those in favor of passage of the bill will vote aye. Those, for what purpose does the gentleman in 36, Doug Green, seek recognition?
Rule 49. Mr. Speaker.
Yes, under the set of facts related to the chair by the gentleman of 36, Doug Green, it is the ruling of the chair. The gentleman belongs to a class of greater than 5 individuals and is therefore eligible to vote on the question. Clerk will please prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the result on this question. There were 92 ayes, 1 nay, and 7 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 5593 relating to the creation, composition, qualifications, and compensation of the State Board of Risk and Insurance Management.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5621, prohibiting the termination of employment of an employee who defends themselves from an attack inside workplace.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 51st, Douglas Fast, to explain the bill. Gentleman from the 55th, Douglas Akers, to explain the bill.
Thank you, Mr. Speaker. House Bill 5621 amends the West Virginia Code to provide that any person who is physically attacked by another, not a coworker, at their place of employment and who uses a reasonable proportion of force to defend themselves or others shall not be subject to any adverse employment action, including termination, solely for the use of reasonable proportion of force. I urge passage and reserve the right to close. Thank you, Mr. Speaker.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? Does the gentleman wish to close debate on the bill?
Thank you, Mr. Speaker. There's been some discussion from some folks asking if this somehow prohibits the employer's right to terminate for at-will employment. I will tell the body quickly that this actually just codifies a current common law exception. In 2001, there was a West Virginia Supreme Court case, Feliciano versus 7-Eleven, in which an employee was terminated after defending himself and some co-workers during an armed robbery, and our Supreme Court held that that employee could not be terminated for exercising their right to self-defense. So this has been a common law exception to the at-will doctrine since at least 2001. This continues to be litigated at times, and what we have now is a common law definition or common law description of what that self-defense means. So what this would do is we would actually legislate and codify what it means to exercise your right to self-defense and actually provide clarity to employers. So I do urge passage. Thank you, Mr. Speaker.
Question now before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 91 ayes, 5 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5621, prohibiting the termination of employment of an employee who defends themselves from an attack inside workplace.
Are there title amendments?
Delegate Akers moves to amend the title.
The question is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5647, increasing and maintaining the bracketed tax rates on the privilege of establishing or operating a health maintenance organization.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 12th to explain the bill.
Thank you, Mr. Speaker. This bill would modify current law imposing an annual broad-based health care related tax, the provider tax, on each health maintenance organization in the state. The tax revenues are used as matching funds to maximize federal Medicaid funding that would increase Medicaid reimbursements for a type of HMO known as managed care organization. The bill proposes new tiers for tax for the fiscal year beginning July 1 of 2024, with new language directing the Commissioner of Bureau of Medical Services to adjust the tax rate each year thereafter for the corresponding tiers for the tax as necessary to maintain revenue at 6% of cost of care ensured in compliance with the code. I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There were 93 ayes, 2 nays, and 5 members absent. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title. Clerk will please report the title.
House Bill 5647, increasing and maintaining the bracketed tax rates on the privilege of establishing or operating a health maintenance organization.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 5662, relating to adding person in a position of trust to certain crimes.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 8th to explain the bill.
Thank you, Mr. Speaker. This bill amends the West Virginia Code to add the term person in a position of trust in relation to a child as defined in 61(8)(d)(1) to crimes of murder of a child by refusal to supply necessities or by delivery of a controlled substance, death of a child by child abuse crimes, child neglect, and child neglect with death crimes, and crimes involving female genital mutilation. That is a brief summary of the bill, Mr. Speaker.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There were 97 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 5662, relating to adding person in a position of trust to certain crimes.
Are there title amendments?
Delegate Kelly moves to amend the title.
Questions on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Opposed, will please say no. The ayes have it. The chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5690, creating a West Virginia task force on artificial intelligence.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman of the 21st, Cannon to explain the bill.
Thank you, Mr. Speaker. This bill creates an AI task force under the Office of the Governor, names its members, assigns their duties, outlines the areas of their inquiries, requires reporting, and establishes deadlines. The task force must recommend to the legislature a definition of artificial intelligence, determine the relevant state agencies to oversee AI policy, and develop best practices for public sector use of AI. The task force will hold its first meeting no later than 120 days after the effective date of the bill, will submit a report to the governor and legislature by July 1 of 2025, and will terminate on that date or upon submission of its report, whichever sooner. Mr. Speaker, I urge passage.
You've heard the bill explained. The question now before the House is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 95 ayes, 2 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 5690, creating a West Virginia Task Force on Artificial Intelligence.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
House Bill 5694, relating to the Firearms Industry Non-Discrimination Act.
Are there objections to having this bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 68th, Delegate Phillips, to explain the bill.
Thank you, Mr. Speaker. The purpose of House Bill 5694 is to prevent financial institutions that do business or have contracts with this state from discriminating against firearm entities and firearm trade associations. The bill does so by prohibiting state entities from entering into contracts with any financial institution that discriminates against firearm entities and firearm trade associations. The bill also prohibits financial institutions that have entered into such contracts with the state from subsequently discriminating against firearm entities and firearm trade associations. The bill provides any such discrimination that does occur may be addressed via private right of action and enforcement by the Attorney General. I urge passage.
You've heard the bill explained. The question now before the House is shall the bill pass. Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There were 96 ayes, 1 nay, and 3 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 5694, relating to the Firearms Industry Non-Discrimination Act.
Are there title amendments?
Delegate Phillips moves to amend the title.
The question now is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have. The chair declares that title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Are there other bills on third reading? If not, bills on second reading.
Senate Bill 600, revising criteria for receiving reenlistment or retention bonus.
Are there amendments? If not, the bill will be advanced.
House Bill 4855, required Division of Purchasing to write contracts in an unbiased manner.
Lady from 71st, Delegate Kimball.
Thank you, Mr. Speaker. I ask unanimous consent that the bill be advanced to third reading with the general right to amend.
Are there objections? No objections are heard, and the bill will be so advanced. Next bill on second reading.
Committee substitute for House Bill 4967, relating to the administration of the Voluntary Remediation and Redevelopment Act to provide new liability protections for persons and companies who wish to purchase and redevelop former industrial properties.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 4999, creating exception to spousal privilege.
Are there amendments? If not, the bill will be advanced.
House Bill 5039, relating to authorizing the West Virginia Division of Motor Vehicles to enforce administrative penalties for the civil offense of refusing a secondary chemical test.
Are there amendments?
Delegate Nestor moves to amend the bill. On page 1.
Are there objections to allowing the sponsor to explain this amendment in lieu of having the amendment read in full? No objections are heard, and the chair recognizes the gentleman from the 66th District, Delegate Nestor, to explain the amendment.
Thank you, Mr. Speaker. In order to understand the amendment, we're going to have to do a little bit of explanation about what implied consent is so that the body understands what that concept means. Implied consent is simply a term for when drivers like us, West Virginia driver's licensees, have agreed to submit to a secondary chemical test if we are pulled over by, say, an arresting officer or an investigating officer under the suspicion of driving for DUI. And so implied consent is not a criminal penalty. What it is it's an administrative penalty that can be imposed by the Division of Motor Vehicles if you're offered a secondary chemical test of blood, breath, or urine under suspicion of DUI and you refuse to take that, all right? And that applies to every single West Virginia driver's licensee, including people from out of state who may be traveling through the state of West Virginia, okay? So now that we understand what implied consent is and isn't, it's not a criminal penalty, it's instead a civil suspension type of a penalty that's administered through the Division of Motor Vehicles. I want to talk a little bit about the recent history of implied consent law, because that's absolutely necessary to understand the effect of the amendment being proposed before you. Prior to July 1st, 2020, the Office of Administrative Hearing Examiners, which was overseen by the Division of Motor Vehicles, was in full force and effect. And what that division had was a panel of hearing examiners who would answer 4 questions in a alcohol-related driving offense charge. Okay, so you had 2 courts of competent jurisdiction. You had an administrative court, which was overseen by the Office of Hearing Examiners with the Division of Motor Vehicle, and you had a criminal court, which was usually the West Virginia Magistrate Court system. So the Magistrate Court system, if somebody was charged with a DUI, whether they were fined or penalized or jailed or actually convicted beyond a reasonable doubt, was conducted in the magistrate courts by elected magistrates, and you'd have to be convicted of that offense of DUI by a reasonable doubt. Then, very confusing, and this whole setup was very confusing to legal practitioners and West Virginians alike, you would have actually a second hearing at a Division of Motor Vehicles. So your local DMV would then have a hearing, and that hearing would be conducted before a hearing examiner that was appointed by the Division of Motor Vehicles. And in fact, the Supreme Court held that if you went to trial, for an example, in front of a jury of your peers at a magistrate court or at a circuit court for a DUI criminal offense and were found not guilty, you could still lose your driving privileges at the subsequent administrative hearing that would be conducted at the DMV, the same place that you would get your driver's license or apply for a driver's license, or if you were 16, you were taking your driver's test. They actually have a room back then, prior to July 1st, 2020, where there'd be an administrative appointee from the DMV that would decide by a preponderance of the evidence 4 things. And one is very important for this body to understand. Of those 4 things, one was the secondary chemical test offered? Was it refused? Were the required verbal and written warnings administered with respect to the secondary chemical test? And the primary and 4th question being, and which I think to be the most important, is was there reasonable grounds to believe that the licensee was DUI? And that is a legal question. Now, enter Senate Bill 130, which was enacted and went into full force and effect on July 1st of 2020. What that bill did was it took the authority from the DMV to conduct these hearings and thereafter enter an order suspending your driving privileges if you refused a secondary chemical test. And it remanded that authority to a single court, making it an efficient system. It put it in the magistrate court system of the state of West Virginia, where our elected representatives are. And so what would happen is that every time, under the current state of the law, under Senate Bill 130 and its ramifications, when anyone was accused of DUI within the initial appearance of that particular defendant before a magistrate, it was incumbent upon that magistrate to advise the defendant that they had a right to a refusal hearing within 30 days. Within 30 days of their initial appearance before them, which at all relevant times had to have been when that individual was arraigned. And what arraignment is when you come before a magistrate or you're in jail and he or she shows up on a teleprompter, they say you're being charged with the offense of DUI and on the following date, and we're going to set your bail, and this is what you're going to need to meet in order to get out of jail. And that's the initial appearance that the present law contemplated. So the problem has become is that the officer has to submit what's called a Form 314 to the Division of Motor Vehicles within 48 hours of an alcohol-related driving allegation. Officers, I'm hearing upon inquiry from magistrate courts that sometimes they do this. I'm also hearing that sometimes from other magistrates that if the officers are doing it, they're not getting the forms. But the problem with the current state of the law, and what I think 5039 is seeking to fix, is only 8.5% of our magistrate courts are actually conducting these refusal hearings. I don't know whether the data is because only 8.5% of implied consent defendants are asking for the hearing, 8.5% are asking for the hearing and not getting it. I don't know what the circumstances are, but I do know that it's 8.5% of these hearings, only 8.5% of these courts are conducting these hearings, okay? So the issue becomes that if 5039 becomes law without the amendment, we're going to revert back to the way the law was prior to July 1st, 2020. So now the Division of Motor Vehicles is going to have the ultimate authority as to whether or not somebody was offered a chemical test and refused that chemical test, and they're going to enter an order within 30 days of receipt of this Form 314 that's received solely from a police officer. Now, I think that's a very inefficient system. It's also a very confusing system. So with the amendment, what the amendment will do is leave that discretion within the jurisdiction of our elected officials and magistrate court. And what it will do is it'll mandate that our judicial officials shall conduct these refusal hearings at the defendant's initial appearance before the court. So it will be at the defendant's initial physical appearance before the magistrate courts. These hearings shall be conducted. So if someone's accused of DUI and they're also accused of implied consent, what's going to happen is they're going to show up at the pretrial conference or the preliminary hearing, and the magistrate is going to have the refusal hearing. All right, so what this bill does is it strikes, I believe, to be a perfect balance between the procedural due process rights of West Virginia drivers, rights that we expect to have as West Virginia citizens, because we want our elected judicial officials making legal determinations, not a DMV assignee making a determination based on a report from a police officer that we've never had an opportunity to contest. Another issue that this amendment, if adopted, will resolve is a financial issue. And that is that there'll be many, many people. I represent people accused of DUI and implied consent a great deal in my practice of law. And what I can tell you from that is many of my clients are adolescent college students. They're military people that don't live in the state. And when the DMV is only going to send notification that your license is revoked to the address on your driver's license. So oftentimes there are going to be people that are implied consent that our Division of Motor Vehicles, if this bill passes without the amendment, that either don't get notification or get late notification, are actually pulled over for, say, speeding or running a traffic light or something relatively innocuous, and they're going to go to jail because driving on revoke for a DUI when your license is suspended for a DUI is a mandatory jail sentence. So we're going to have a swath of people that we're paying for that are in jail for crimes that they didn't know they were committing if this amendment isn't adopted. So I hope the body understands. I reserve the right to close, and I'll be happy to take any questions. I urge adoption. Thank you.
You've heard the primary amendment explained. Clerk will now report the secondary amendment.
Delegate Linville moves to amend the amendment on
Are there objections to allowing the sponsor to explain the secondary amendment in lieu of having it read in full? No objections are heard. Gentleman, the 22nd, Douglas Linville, to explain the secondary amendment.
Thank you, Mr. Speaker. The reason for this bill is a concern relative to the enforcement of these implied consent hearings. And part of the reason why we have these implied consent hearings is that it actually is mandated by the federal government in relation to Federal Motor Carrier Safety Administration, Federal Highway Administration, and National Highway Traffic Safety Administration dollars for your road fund. Okay, so on federal aid eligible projects and those things. So as the gentleman stated, back in 2020, there were significant changes made to the sort of bifurcated process surrounding DUI. And so as a result, with the gentleman's amendment, it would leave this with the courts, but we have to ask ourselves why these hearings aren't taking place. And so the answer to that, at least it's been alleged by some, is that there is nothing in it for that court to ultimately adjudicate that case. They've got the criminal case in front of them, they've got fines and penalties. This is solely an administrative process. And so it's basically more work, but with no benefit to the area. And so as a result, in 2021, 8.5% of the alleged cases were affirmed. In 2022, 15.2%, and in 2023, 12.2%. I am in possession of communication from the Division of Motor Vehicles, which would state that FMCSA has asked for that data after the passage of Senate Bill 130. And if the state of West Virginia were sanctioned just on what's already happened, that we would lose as much as $19 million in road surface fund penalties. But if that were to get larger and the other agencies were to take a look at that, within 2 years that could be $100 million. $100 million. So the effect of my amendment would be to provide that if we're not going to do this on a state level, though it is state funds that are in jeopardy, if we're not going to do this at that state level, then it would simply state that semi-annually, so twice a year, the courts of competent jurisdiction would submit the data to the Division of Motor Vehicles, which would include the following. the number of refusals of the implied consent that were alleged, the number of hearings that were held, and the ultimate dispositions thereof. Now, why do we want that data? The answer is what the amendment goes on to do. And in the event that a lack of enforcement of that implied consent law does in fact diminish our federal funding for these projects from any of those agencies that I've already mentioned, then the Department of Transportation and Division of Highways would cause the apportionment of resources. So we've got our road funding model and formula that we have, would cause the apportionment of those resources devoted to the jurisdictions of those particular courts which would cause us to lose these dollars to be diminished accordingly. So with that, there is now reason for those courts, and there's accountability as well, to hold those hearings and to ensure that if it is their lack of action, as has been alleged, and I'm not alleging that, but as has been alleged, and as is the reason for the ultimate bill, that if we're going to lose road dollars, it comes from the areas that caused it. And so as a result of that, I would urge adoption of my amendment and reserve the right to close. Thank you, Mr. Speaker. Excuse me, my amendment to the amendment. Thank you.
Question is on the secondary amendment. You've heard the secondary amendment explained. Is there debate on it? Gentleman 37, look at Gearhart.
Thank you, Mr. Speaker. Could I ask the gentleman to yield?
Yes.
Just a question with regard to process. Obviously, magistrates typically represent counties.
Correct.
And counties are part of the different districts where the highway funding is allocated.
Correct.
So typically that funding that is allocated to those districts is not allocated to those districts by county. It is in a bulk according to the need within that district. It may be 4 counties in that district, yours and mine. Yours may have more need, and so more of that money gets spent in your county. How would you deal with that juxtaposition within what the magistrate's activities do within a portion of that district to the method with which Highways currently funds that district?
So I wouldn't fully agree with the gentleman with the means by which those dollars go out. Each county does, as we were looking in 2019 and 2020 at some of the potential things, and forgive me with a little latitude, Mr. Speaker, we had, if you'll recall, Randy's Dream, that bill, and we had the Country Roads Accountability Act over here. We got a significant amount of data that would go into, there was some district level money, that generally goes for the bridge department, that goes for the sign shop, some of those things, but each individual county actually had a further disposition of those dollars within those districts. We have reports on that that I've individually seen. And so in the instance of a county, I think that's both very doable. And when I discussed this with DMV this morning, they said that their ultimate concern is the road fund dollars, and that if my amendment to the amendment were adopted, that they felt like that would be a means by which to ensure that this would happen. Additionally, the amendment to the amendment does not state the means by which that has to happen. They can develop that formula if that were necessary, but it does state the resources devoted to the jurisdiction of the court so responsible. And so I believe, to the gentleman, my colleague and a former chair of the committee that I presently chair, that it is doable, and that your concern might be met as contemplated in the amendment.
Thank you, Mr. Speaker.
Gentleman from the 76, Garcia.
Will the delegate from the 22nd yield?
Yes.
Okay. So we don't have a funding formula for regions or counties under the Division of Highways system, do we?
Yes, we do.
We have a formula that's put in code for how they provide for funding equally among all the different counties or regions?
Equally is not certainly the way that I would describe that. There is a very long funding formula, which I'd formally given to the gentlelady from the 4th, that's in also the possession. I know you also sit on the Department of Transportation Accountability Committee. Staff has been provided that no fewer than 4 times from the Secretary to former Delegate Zukoff's request, and we can hand that formula over to you at any time.
Well, but they have formulas, they have the ways to do it. I know my friend, the gentleman from the 80th, has done a bill multiple times to try to get equal funding to different places, but you're basically saying they're going to have ability to use their internal formulas to take funding away, funding that would go towards roads in areas where magistrates have made a decision about how often, I guess, or how they do implied consent laws. Is that correct?
So if the ultimate result of the cases or the lack of enforcement of the law in those areas, which again, we can't legislate, right? We cannot force a court to hold a hearing. And I mean, the gentleman practices in the courts, and I don't. But the intent here is to solve the problem. The gentleman from the 66th ultimate amendment would say, look, let's not take this back to the state level. And if it's all the state's dollars that are essentially impacted here, all right, if we'd like to improve the gentleman's from the 66th Amendment, and we leave that with the courts, right? Those courts so responsible if we were to lose those dollars. The jurisdiction of those courts, the areas in which they are operating, are the areas that should be penalized, and not that of the entirety of the state.
So like Region 6, Region 4, I mean, it's going to probably be done by region, correct?
No, to my answer to the gentleman from the 37th there, I feel quite confident that would not be the case. Don't forget, some of these are even heard in municipal court, so because this is implied consent, so it's not just magistrates. So you could even get down to the municipal boundaries.
Isn't there also the possibility of a mandamus from the Division of Motor Vehicles just to hold them accountable as opposed to this really complicated formula?
No. I mean,
I disagree with you.
How would you envision that?
I disagree with you, but okay. I'll speak to the bill. I think this is a little bit too rough of an idea for this morning. I think we already have potentially, I'd like to see our funding formula do a better job of providing equitable resources across our state. And I do think that there is the possibility that the Department of Motor Vehicles, the easiest way is if there are magistrates or municipal judges across the state that are not doing their job, the DMV can use the mandamus process, which is currently afforded to them. And for that reason, I'd oppose the secondary amendment.
The question still is on the secondary amendment only. Gentleman from the 17th, Dr. Pinson.
Thank you, Mr. Speaker. Question of the chair. I just want to make sure that I understand this before I ask questions to the gentleman of the 22nd. The secondary amendment would replace the primary amendment if adopted. Is that correct?
It would not.
It would not?
The secondary amendment is additive to the primary amendment.
Okay, thank you. I wanted to be certain to understand that. Would the gentleman yield? Thank you. Thank you for yielding, Mr. Chairman. It's my understanding that if the bill is adopted, the hearing for the failure to comply to the secondary test, or to the chemical test, rather, that moves out of the court.
Correct.
And it goes back to the DMV.
If the bill were unamended, the answer to that is yes.
Okay, so your amendment would work in conjunction with my friend's amendment from the 66th. It wouldn't replace it. It would work in conjunction with.
That is correct. The underlying thought process behind my amendment to the gentleman's amendment is that if the gentleman's amendment were adopted, right, the only difficulty that we would have with his amendment as it stands, right, without my secondary amendment here, is that there is no incentive or accountability necessarily to the judiciary in those particular areas that are presently at least alleged by FMCSA to be out of compliance, and therefore potentially costing us at this point $19 million, but again in 2 years up to $100 million.
Would it be that number of millions of dollars in perpetuity if we continue to fail to comply, right?
I believe that upon full implementation it would be roughly $100 million.
Okay, so here's a question. I don't mean this to be a gotcha question, but if your amendment passes, we're getting ready to vote on your amendment. If your amendment passes, do you then plan on supporting the gentleman from the 66th Amendment?
I do.
Do you, again, not trying to back you into a corner with a gotcha question, do you not believe that the bill as we had it before both of your amendments was a far better approach to address this problem?
I could go either way on that, to be honest. Without my amendment on the gentleman's amendment, I would have concerns with the gentleman's amendment. With my amendment, there's two items that we have to consider. Number one, what our colleagues in the Senate would be desirous of doing. I do believe in the gentleman from the 66 argument that elected officials tasked with judging their peers, really, their fellow citizens, is better than an administrative process. I do, in fact, believe that. However, I also have my significant concerns that the status quo is what it is, and that if left there without any accountability, that the status quo could remain.
Excellent. Thank you for yielding. Mr. Speaker, I'll speak to the amendments.
Yes,
just
gentleman's
really quickly,
recognized for that
please.
purpose.
So I appreciate the gentleman from the 22nd and his willingness to work with the gentleman from the 66, but I'm going to urge rejection of both amendments, both the gentleman from the 22nd Amendment and the primary amendment, the gentleman from the 66. And the reason for that is the bill prior to being amended was the solution to fix this problem. The courts of competent jurisdiction were not handling these cases in an efficient manner. They weren't following up. So we're talking about an administrative function. If someone refuses to take a breathalyzer test back at the police station or refuses to submit to a blood test, they deserve to have their driver's license revoked. And you want their driver's license. I want their driver's license revoked because they're going to be potentially on the roads with my family. I realize that just having their driver's license revoked doesn't mean they're not going to get behind the wheel of a car, but if they do get behind the wheel of a car, it's now an additional crime. If they get caught 3 times, it's a felony. The bill, before any amendments were added on, addressed the problem. I would urge rejection of both amendments and pass the bill. Thank you, Mr. Speaker.
Gentleman from the 55th, Douglas Akers.
Thank you, Mr. Speaker. Will the author of the Second Amendment yield?
Yes.
Thank you, sir. So, as it stands now, you're saying that the problem already exists, that we have magistrate courts or municipal courts that are not doing their jobs.
That is the allegation from FMCSA.
Okay. So how long has that problem been going on?
Since the passage of Senate Bill 130 in 2020.
So why has I'm not saying you're supposed to know the answer to this question, but I know you've had extensive discussions with DMV or FMCA. Why have they not done something before now?
So I will go actually into the DMV's response there, because in even entertaining this bill, I wanted to better understand this. And by the way, this bill comes to us by request of DMV. So while I'm the sponsor, that's in my role as chair of the committee. So CFR 383.72 will deal with your CDL holders and potential DUI convictions. But in relation to that happening under a commercial, I'll say it here in a minute, commercial motor vehicle must be involved in that DUI for that to have gone through that traditional process. So then FMCSA, in looking at this, saying, hey, we're seeing some CDL holders who have been alleged to have violated the implied consent, or who have been alleged to have been DUI in a non-commercial motor vehicle, are not having this done. So they began to sort of track this down over a period of time. And then, as I understand it, FMCSA reached out towards the end of last year, perhaps early this year, and asked for the data. It was in 2022. They asked for the data for 2022 and then in 2023. And so as this has sort of matriculated through the process, we're now at the point where FMCSA is beginning to say that they may sanction the state of West Virginia due to their finding, which is that the implied consent issue is not making accurate DUI convictions or holding the hearings and affirming the allegation of the officers.
So is this a CDL problem only, or is it an all license holder problem?
It is both. The canary in the coal mine is relative to CDLs.
Okay. All right. So how long has DMV known that this was not being handled appropriately?
Well, DMV has the following data. They don't have. So my amendment actually also deals with some of the data, and there's been actually lengthy discussions between the gentleman from the 66th and I. And the following data is what is available to the DMV. In 2021, there were 538 implied consent cases, so allegations, as I understand it, that or excuse, this may even just be hearings, we don't really know, or hearing requests. 538, only 46 were affirmed for 8.5% of total cases affirmed. In 2022, 559, 85 affirmations, 15.2%. 2023, 687 affirmations, 84 for a total of 12.2%.
Maybe I'm not being clear, maybe there's no answer to this, but I'm trying to figure out, though, how long has DMV known that that's been happening?
So the policy became law July 2020. I think then they began to get some of this aggregate data. Obviously, during 2020, you had the coronavirus pandemic. You had many DMVs shut down. You had some of those things. So at least as I can best understand it, they recognized there was a problem as FMCSA reached out in 2022.
So DMV has known about this since at least 2022.
That would be based upon the information that I have. Yes, and by the way, the DMV did oppose the repeal of their office administrative hearings in the first place.
When DMV found out about this in 2022, did they notify the court system, the Supreme Court of Appeals, or any of the magistrate courts, or any of the counties that were apparently out of compliance?
So I can't speak to that.
Okay. How will the data, and I think the intent of your amendment, I understand it and don't oppose the intent, but in terms of the data collection with regard to the particular courts or counties of jurisdiction that may be out of compliance in the future if your amendment is adopted, how do we collect that data?
So that data is submitted by those courts themselves in the amendment. So the amendment reads, the courts of competent jurisdiction shall semi-annually report to the DMV the aggregate number of implied consent refusal hearings held, the number of implied consent refusals alleged by police officers, and the dispositions thereof. So they would be submitting that data. Each court of competent jurisdiction would be submitting that data to the DMV.
And you said that potentially $100 million in funds are at issue going forward.
That's correct.
So how out of compliance would we have to be with regard on a county-by-county basis before we would get to $100 million? In other words, we have 55 counties in the state. I mean, if 20 counties were out of compliance by a certain percentage, would that get us to $100 million? If it was 10 counties, I mean, I don't know what the percentage of compliance would have to be before we're at that level of risk of federal funds.
So relative to a percentage compliance, I don't know that I can give you the answer, but the data that I do have is that when you combine FMCSA and FMCSA and NHTSA funding, that in year one, that can get up to, if memory serves me, please don't hold me to this, roughly $60 million, and in year two, $100 million.
So just for argument's sake, there could be 10 counties in the state who are out of compliance to the extent that it would cost us $100 million in federal funds, and only those 10 counties would be penalized, I guess, at the rate of, if we average it, $10 million apiece in highway funds.
I want to make sure that I'm accurate in the intent of the amendment. The intent of the amendment to the amendment is that, yes, only those areas would be penalized, but again, it does say diminished commensurately. And so the intent there is, look, if a county's getting, if a county has cost us roughly 8% or 10% of our federal highways dollars, then 8 to 10% of their federal highways dollars that they would otherwise receive from the state would be diminished.
All right, thank you. Mr. Chair, may I speak to the bill quickly? Or Mr. Speaker, I'm sorry.
To the secondary amendment, yes.
Secondary amendment, I'm sorry, yes. I think the intent of this secondary amendment is well-intentioned, but I think it was just done within the past 24 hours. This is extremely complex. I'm frankly not, based upon my experience with the court system, I'm not comfortable that the court system will even be able to accurately report this data, and we could wind up with a situation where the citizens of a particular county are penalized for something that's not their fault based upon what happens in their particular court of jurisdiction that might actually appropriately report the data, but it's not accurately received, or something else could happen in between. I'll also say, if DMV knows this is happening, not blaming them, but they have mechanisms in place legally to force these court systems to comply if this is a federal mandate, and that's probably what should be happening first. I was going to support the initial primary amendment, but if we have to adopt both of these, I'm going to have to oppose both now. I think this puts a lot of people at risk who otherwise should not be. Thank you, Mr. Speaker.
Gentleman, the 98th, Elgin Espinoza.
Thank you, Mr. Speaker. While I appreciate the chairman's efforts to make the primary amendment more palatable with his secondary amendment, I'm also going to rise to respectfully urge rejection. I think my concern is that my county, my district could very well be negatively impacted through no fault of my constituents at all. If you happen to have a magistrate in your area that does not comply with this scheme as outlined under the primary amendment, essentially you're going to suffer as far as having less highway funds for your particular area. And as a colleague pointed out this morning during a conversation, even a neighboring district, a neighboring county, if they lose funding, their road quality suffers. It very well could impact my constituents. I know in the Eastern Panhandle, many of us frequently are driving through the three, at least the two most eastern counties, sometimes the third most eastern county. If any of the three had a magistrate or magistrates that weren't complying, it certainly is going to negatively impact the road quality in our area. So again, I do appreciate the chairman and his efforts to try to perfect this primary amendment, but I'm going to urge rejection of the secondary amendment. Thank you, Mr. Speaker.
Question still is on the secondary amendment. Is there other debate on the secondary amendment? Gentleman from the 100th, right now is recognized.
Thank you, Mr. Speaker. Will the chairman yield?
Yes.
So if we lose, as you project, or as DMV projects, $19 million, that $19 million would be spread across the state, correct?
That's correct.
If we lose $100 million, that will be spread across the state.
That's correct.
So that appears to me to be collective punishment. Would that be a fair characterization?
That's correct.
So what we're doing is we're punishing everyone in the entire state if we do not adopt your amendment and the other gentleman's amendment does pass, correct?
Yes, so allow me to, in response to your question, perhaps even just somewhat in response to the gentleman from the 98th, the underlying question of the bill, the underlying reason for the bill, are these federal highways dollars. What my amendment to the gentleman's amendment would seek to do, obviously, okay, if those courts wish to retain that responsibility, that arguably, at least allegedly, and again, not from me, according to FMCSA and some of the data that we've gotten from DMV, that they've had that responsibility and they have failed to carry it out. If they wish to keep that responsibility, then they should be the ones responsible for the loss of funding. If what the underlying bill requests is to bring that responsibility back to the state, and therefore that's to individuals answerable to the entirety of the state, to this legislature, and to the governor more generally. To be clear, from my perspective, I could go either way. However, with my amendment, I would be happy to support the gentleman's amendment. I do think that the best judges of their peers are those more local to them. So they're local circuits or magistrate judges or even city judges. But to the gentleman, you are 100% correct that actions of in the gentleman from the 66th district, he had indicated that his magistrates are in fact holding these hearings and they are in fact adjudicating them and that they are doing their job. If we were to lose these federal highways dollars, they would not be apportioned, to everyone but the gentleman from the 66th district under present law, and that would be unfair to those who have been enforcing our laws.
Thank you very much. Speak to the bill, Mr. Speaker.
Yes, gentleman's recognized.
I've listened
for the secondary amendment. Yes.
On the secondary amendment, but I would first like to address my friend from the 66 amendment, because I think I've listened to my friend from the 66 discuss this issue both in judiciary, in caucus, here on the floor, and he has some very persuasive arguments, and I think that those have some validity, and I think that potentially is a good solution. But I think that if we do not do something to preserve for our entire state those federal dollars, then we are in some serious jeopardy. So I would support the chairman's amendment to the amendment. I believe that we have to be looking at this from not a parochial perspective in terms of our specific locations, but across the entire state. We're potentially endangering our ability to maintain our roads across the entire state. We need to encourage, if we adopt the gentleman from the 66th amendment, We need to encourage those recalcitrant magistrates to actually do their duty and ensure that we are forcing them to take responsibility for their actions. This is one way of doing it. It may not be the best way. I can't say what the best way would be until we've actually tried something. But I think at this point, it's a good idea to adopt the chairman's amendment to the amendment. Thank you very much.
Gentleman number 67, Dr. Coop Gonzalez.
Thank you, Mr. Speaker. I'd like to speak to the secondary amendment.
Gentleman's recognized.
So I think the biggest argument against the chairman's amendment is that, well, what if a magistrate doesn't do their job? But the issue is that the magistrates already aren't doing their job, and we're all going to lose money unless we put teeth in this bill. And I really think that that's what the chairman is accomplishing with this. So I think it's very important. It should pass. Thank you.
Is there other debate on the secondary amendment? The secondary amendment. If not, shall recognize the sponsor. Gentleman, the 22nd, to close debate on the secondary amendment.
Thank you, Mr. Speaker, and colleagues. I appreciate the indulgence. I appreciate the true debate that we've had here on the floor during the consideration of this amendment to the amendment. Friends, I would ask your support for this secondary amendment, the amendment to the amendment, in that it certainly improves the gentleman's amendment. Now, the gentleman will make the case for, and if adopted, I can support the gentleman's amendment. But I would ask that you not consider your argument or your decision on his amendment solely as you vote upon the amendment to the amendment. I wish for our courts to be successful. I have a lot of trust in my judges and magistrates. I know them well. But I think that with rights, the right to hear these cases, right? The responsibility must come as well. And if we're going to have collective responsibility, we must hand that to those who are responsible. Sitting here talking with counsel as we've discussed the arguments, what else could we do? If the status quo were prevailed, what else is there for us to do? The only answer to that is to get the data from each and every one of them, and those who cost us $100 million potentially of road funding, is to impeach. I don't think that's the right move. I don't think that's the right move. I'm not alleging that that's the right move, but what I am saying is that inaction and the status quo would cost us significantly on something that we've worked very hard to improve, that being our roads. And I think our constituents deserve every last resource that we can devote to them for our road funding, and therefore, Mr. Speaker, I do urge adoption.
Debate on the secondary amendment has been closed. Those in favor of adoption of the roll call is demanded. Is the demand sustained? Demand is sustained. The question is, shall the secondary amendment be adopted? Those in favor of adoption of the secondary amendment will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there are 38 ayes, 55 nays, and 7 members absent, but less than a majority voting in the affirmative. The chair declares the secondary amendment lost. The question is now again on the primary amendment. Is there a debate on the primary amendment? Is there debate on the primary amendment? If not, shall recognize the sponsor, gentleman to 66, to close debate on the primary amendment. Delegate Nestor.
Yeah, thank you, Mr. Speaker. For this body to make a meaning and purposeful vote, I need you to follow one concept very closely with me. If I can get one thing across in this closing, it needs to be this. As I stated earlier in this presentation, when a police officer suspects somebody and pulls a driver over for what they believe to be an alcohol-related driving offense, and they in fact arrest and charge someone with an alcohol-related driving offense, they have to file a form within 48 hours of that arrest. Anytime I can tell you as a legal practitioner that somebody is arrested, they're usually incarcerated that evening for DUI, and there's something called a prompt presentment rule, all right? And at that moment, under the current state of the law and under the current rubric of House Bill 5039 without my amendment, that magistrate still has to advise that particular criminal defendant of their right to request a refusal hearing within 30 days of their initial appearance before them. Could be through teleprompter, could be through in person. It's going to be an arraignment. Okay, so what's important to take from this is that the police officer doesn't have to notify the division of the alcohol-related driving arrest and the fact that there's an implied consent allegation within 48 hours, and the person is appearing before the magistrate in almost all instances within 24, maybe sometimes 12 hours, 18 hours after their arrest, how would that magistrate know to properly advise and preserve that defendant's due process rights by saying, hey, Mr. Defendant or Mrs. Defendant, you have a right to this preliminary or this refusal hearing within 30 days of your arrest, of your 30 days of this interaction between you and I. They wouldn't, because it's preposterous to believe that an elected magistrate who receives training through our Supreme Court is absolutely ignoring the laws of this state. No magistrate in any county is basically not performing these refusal hearings because they know they should and they don't want to do them because they're lazy. They're not doing them because there's legal complications with them. That's the only thing I've been able to deduce through inquiry, through research, and through my work on this amendment and this bill. All right, what's going on here is like I said earlier, there's 4 questions that need to be resolved. You either want those 4 questions in the context of an implied consent allegations resolved by some administrative person in Charleston assigned by the DMV, all right? And those 4 questions, one of which, and I'm not going to go back through them, is very important. It's a legal question. Does the arresting officer, did they have reasonable cause to believe someone was DUI? Now, do you want an elected judicial official in the state of West Virginia to make that determination, a unified, efficient hearing at their initial appearance before the court? That means at their pretrial conference or their preliminary hearing on a felony DUI, or do you want that to be sometime, by Zoom in front of an administrative hearing appointee who has dissimilar training and is certainly not elected, okay? I'm opting for the former. I'm opting for a magistrate to conduct the hearing. Okay, so here's something that is really, really important. Magistrates have to conduct these hearings if this amendment is adopted, regardless of whether there's a fiscal penalty, because as the gentleman elicited earlier from the 55th, from the gentleman from the 22nd, this wasn't an issue for the DMV. We haven't lost a single federal dollar yet. It's been the law for 4 years, all right? If these hearings haven't been being conducted, these refusal hearings, we haven't lost a single dollar anyway. What we are going to lose if this amendment doesn't pass is real dollars, because we're going to have a swath of people driving unknowingly and without the intention to commit a criminal offense, unknowingly without a driver's license that is suspended by the DMV that they don't even know about for DUI. And when they get pulled over for some innocuous offense, they're going to go to jail, because under 17B43, or it's either 17B34B, it is a mandatory 6 months jail offense. So we're going to lose real dollars out of this by confining them. Real dollars. Not this stuff in the fairy dust that we might lose, and this is what we're afraid of. And we want our power back because we're upset we don't have a bunch of employees under the umbrella of the administrative hearing office anymore that we like to have employed, because that's what was absolved in 2020. So here's the deal. I like to be able to look at my constituents and say, hey, I came down to Charleston as an attorney at law. I understand what's going to happen, and I understand, because I'm not going to win any awards if this amendment gets adopted. I mean, the magistrates aren't going to be very happy with me. But I'm going to side with them when they say, hey, it's not that we're just flippant, we're not going to abide by the law. They're not doing it because they have a reason, okay? And the reason is the notification requirement. That is what I want to press on you. You can't advise someone and comply with their procedural due process rights and advise them of something that you don't know about, because the current state of the law would not even compel them to be advised until after the arraignment. So again, if this amendment is adopted, it will compel magistrates 100% of the time to conduct these refusal hearings at the person's initial physical appearance before the court. And how we know these are going to happen? Because I'll tell you something. I can tell you as a legal practitioner, somebody accused of DUI as a pretrial conference of magistrate court of this state is not going to show up for their hearing, because there's something called a bench warrant. The fancy word for it's a capias. They're going to go to jail. So they're going to come to court, and if this amendment's adopted, the law now becomes in this state, Mr. Magistrate, Mrs. Magistrate, you shall conduct that hearing when you first put eyes physically in your court with that defendant. It is a perfect balance, at least in my opinion, of someone's procedural due process rights in the context of the laws, the criminal laws of the state of West Virginia, and the protection of these federal funds that are potentially in jeopardy. So I urge adoption of the amendment. Please vote yes on the amendment. Thank you, Mr. Speaker.
Debate on the primary amendment has been closed. The question now is, shall the primary amendment be adopted? Roll call is demanded. Is the demand sustained? Demand is sustained. The question is, shall the primary amendment be adopted? Those in favor of the adoption of the primary amendment will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There were 75 ayes, 18 nays, and 7 members absent. The majority of members having voted in the affirmative, the chair declares the primary amendment adopted. Are there other amendments to the bill? If not, the bill will be advanced to third reading. Next bill on second reading.
Committee substitute for House Bill 5093 relating to revision of orders concerning distribution of marital property.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 5105 to eliminate the vaccine requirements for public virtual schools.
Are there amendments?
Delegate Hornby moves to amend the bill. On page 3, Section J, line 55, by striking out the word athletics and inserting in lieu thereof the word activities. And on page 3, Section K, line 58, by striking out the word athletics and inserting in lieu thereof the word activities.
Question now is on the amendment just read by the clerk. Chair recognizes the sponsor, the gentleman from 93rd, Delegate Hornby, to explain the amendment.
Thank you, Mr. Speaker. This just simply lines up with WVSSAC activities versus athletics. Thank you.
Gentleman, state the question.
Thank you. Are there other amendments that are competing amendments or in conflict?
The chair's reviewed the amendments. There are other amendments. They do not per se appear to be competing, though. Does the sponsor believe they are?
Yes.
Please approach the podium. Ladies and gentlemen, we do have 4 amendments to the bill. 2 of them do need to be considered simultaneously. You've heard the first of the primary amendments read by the clerk and explained by the sponsor. At this time, we will take the second of the 2 primary amendments that does compete directly with the amendment just read by the clerk. This time, the clerk will please report HFA Pushkin 2-22 number 2.
Delegate Pushkin moves to amend the bill on page 3, section 4, lines 54 and 55 by striking out the words West Virginia Secondary School Athletics Commission sponsored athletics and inserting in lieu thereof the word public school extracurricular and co-curricular activities. And on page 3, section 4, lines 57 and 58 by striking out the words West Virginia Secondary School Athletics Commission-sponsored activities and inserting in lieu thereof the word public school extracurricular and co-curricular activities.
Okay, so at this time, ladies and gentlemen, you've heard both the competing amendments read by the clerk. In a moment, the chair will open debate to both amendments simultaneously. Members may debate for or against both of the two pending amendments. At the conclusion of debate, the chair will recognize the sponsor of each of the two amendments to close debate, and then the chair will take the vote on the more comprehensive of the two amendments first, which will be HFA Pushkin 2-22 number 2. If it is adopted, it will then preclude the lesser inclusive amendment offered by the gentleman from the 93rd, Doug Hornby. If the more inclusive amendment is rejected, we will then move to vote on the lesser inclusive amendment offered by the gentleman from the 93rd. So at this time, debate is open on both amendments as read by the clerk. Gentleman from the 93rd, Doug Hornby.
I ask unanimous consent to withdraw my amendment.
To withdraw the amendment?
Yes, sir.
Okay. Are there objections? Okay, there are no objections heard, so we do not have competing amendment now. So the question before the House is the primary amendment read by the clerk, offered by the gentleman from the 54th, Doug Pushkin. Debate's open on the amendment. Is there debate on the amendment? Excuse me, chair did not afford the sponsor the opportunity to open debate. Gentleman from the 54th to open debate on the amendment as the sponsor.
Thank you, Mr. Speaker. This amendment is similar to the amendment offered by my friend from the 93rd. While I apologize for the late submission of the amendment, I think it's important to also offer this choice, which is a bit more comprehensive than what was offered. I believe that's why my friend chose to withdraw his, because if it was just if the exemption only, if the requirement only pertained to the students that were participating in West Virginia Secondary School Athletic Commission sponsored events, you'd leave out a lot of other types of events, whether it's chess club, a science fair, other things of that nature. So what my amendment says would be, and this uses the language that was in the bill that, as it came out of health, public school extracurricular or co-curricular activities. So it's fairly self-explanatory, but if anybody has any questions, I'm here for you.
Gentleman from the 42nd, Doug Steele, is recognized on the primary amendment.
Thank you, Mr. Speaker. I would rise in opposition to this. One of the things that we talked about in judiciary was what is an extracurricular activity and what is a co-curricular activity. It could include a lot of different things that homeschool students that are not subject to the vaccine requirements that we have in code can go to a public school and participate in right now. They can go and participate in a Cub Scouts or Boy Scouts or Girl Scouts meeting at a local school that could be considered co-curricular or extracurricular. There's a question of if depending on how the posture of the bill comes out, if private and parochial schools were included, would extracurricular activities include participation in WVCAT athletics as opposed to WVSSAC athletics? That's why the term WVSSAC was used, because that encompasses your public school sports activities in which children are going to come into contact with one another in contact sports. While I'm sure chess club is exciting, I don't think many of us would classify it as a contact sport unless you get really mad at your opponent. So hopefully that's not the case. But I think what the amendment is seeking to do is actually exclude more kids, even more kids, from being able to participate in something, just because it could be considered co-curricular or extracurricular. And I've heard no one define what co-curricular even means, or how that word even got into the original bill. I had never seen co-curricular before, and I have not heard a single person define that yet. And I have a feeling that the state medical officer will be the one defining that term for you if you're not very careful. And that's why this was appropriately amended in judiciary. I want to urge rejection of this amendment.
Gentleman from the 51st, Douglas Fast, is recognized.
Thank you, Mr. Speaker. I would also rise in opposition to this amendment. These kids that will be exempted out, if they choose to exempt out, they still commingle in society. They're going to go to church, they're going to go to shopping centers, to Walmart, and different places like that. You know, a lot of us didn't have all these required vaccinations that we require on our kids today. And look around, there's 100 of us in here, and we survived. And so this is not meant to turn into a quarantine of a certain class of people. That's not what it's meant to do. And I'm afraid with the gentleman's amendment, that's exactly what it'll do. It'll go down that road. I would urge rejection.
Gentleman from the 27th, Douglas Griffith, is recognized.
Thank you, Mr. Speaker. I've mentioned this before in our committee, and I want to mention it again. When I was in high school, Cerritos-Canova High School, one of my classmates was let out of class 5 minutes early so that he could make it down the hall on his crutches and braces. Now, he had natural immunity at that point for polio. He only got it once. But many of these diseases that the state health department and the schools require are because of, speaking in general, the general welfare clause of our Constitution and our general ability to protect. A good example is seatbelts. You know, who's the government to tell us to put on a seatbelt? And so we're going to take these kids that have not been vaccinated against measles, chickenpox, polio, some of these diseases, and they're going to put them in with the other kids. Now, it was said, you know, they play Little League, they do these other things. Well, that's not the state of West Virginia, who is required to look out for the general welfare. If parents want to expose their kids to those other things, that's their choice. But in this instance, there are people who are vulnerable. I think of another young man that I knew who had cystic fibrosis. Getting exposed to one of these things with a compromised immune system put him at greater risk. And the unvaccinated are also vectors of spread to our seniors, to everyone. I know we've debated about vaccines, you know, it should be my right, but this is for the common welfare. This is to protect people. And when these unvaccinated children mix with the general population of the school under a state event, it's different than Little League. It's different than all of these other activities. And so I urge support for this amendment because I think we're not taking it 2 and 3 steps beyond as we should. As what are the long-term consequences of this? In many cases, none. In some cases, critical consequences. So please support the amendment. Thank you, Mr. Chair.
Is there other debate on the amendment? If not, Chair recognizes the sponsor, gentleman with the 54th, to close debate on the amendment.
Thank you, Mr. Speaker. Well, I definitely respect the opinion of my friend from the 42nd and value his friendship. I think he's a very smart guy. If I was seeking a legal opinion, he might be one of the first people that I would call. However, if I wanted an opinion on stopping the spread of communicable diseases, I would not call a lawyer. I would call an epidemiologist. And I don't know of a single epidemiologist that thinks it's a good idea to weaken our public health laws in regards to vaccinations. But this is a compromise amendment. This is a compromise. This keeps in the bill the exemptions for children who are in parochial schools, who are in private schools. It simply says that if they want to participate in these activities with children at the public school, then they would have to do what they've been doing for years, what we've all been doing for years, and getting these vaccines to prevent the spread of measles, mumps, chickenpox, rubella, polio. Some of these diseases have been eradicated because of these vaccines. That's a fact. So it's not about excluding students. They could participate in any of these activities they want to, provided they follow the public health rules that we've had in place for years. It's not about excluding children. It's about protecting children and really protecting society as a whole. Now, a friend, the chair of Judiciary, said, well, we don't require that to go to church. Of course we don't. You have a constitutional right. If you have freedom of religion in this country, you can't require anything of anybody to go to a church. You can't require anything of anybody to go to Walmart. They have a right to public accommodations. But you're mandated to go to school up to a certain age, and that's why we attach these requirements to school in the hopes that more folks get vaccinated and we continue to eradicate these horrible diseases that we've done such a great job of slowing the spread of, and in some cases eradicating over the years. Let's not go backwards on this. Let's not go. It's one of the things West Virginia has done very well, and we should be proud of. When you read the papers about measles outbreaks in other states, it hasn't happened here because we have fairly good laws in regards to public health. So this is a compromise. This just restores some of the language that came out of the Health Committee, but this is a compromise. Simply says if they're going to participate in activities, and co-curricular is also defined. I could find the definition of it. Co-curricular, extracurricular activities, if they are going to participate in these activities, they simply need to do what they've been doing for years, and that is receive the vaccine. So I would hope I'd urge the body to support the amendment.
Debate on the primary amendment's been closed. The question now before the House is, shall the amendment be adopted? Those in favor of adoption of the amendment will please say aye. Aye. Those opposed, please say no. Noes have it. Chair declares that amendment. Roll call is demanded. Is the demand sustained? Demand is sustained. Question, for what purpose does the gentleman with 20 seconds seek recognition?
Point of order, Mr. Speaker. I believe you called the vote.
Excuse me?
I believe you called the vote prior to the demand for roll call. You said the ayes have it. Or excuse me, you said the noes have it.
Did I? It is typically the chair's practice to say the chair believes the ayes have it or noes have it. What? Do. The chair's not sure what the chair did, but we're going to respect the rights of people who demanded a roll call vote. Roll call vote was demanded, demand was sustained. Question is, shall the amendment be adopted? Those in favor of adoption will vote aye. Those opposed will vote no. The clerk will prepare the machine. Okay, has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 32 ayes, 63 nays, 5 members absent, less than a majority in the affirmative. The chair declares the amendment lost. The clerk will now please report Amendment Kirby 2-23, number 1.
Delegate Kirby moves to amend the bill on page 3, section 4, after line 58, by inserting the following language. L, notwithstanding any other provisions
For what
of this
purpose does the
code.
gentleman of 44 seek recognition? Dr. Kirby?
Unanimous consent to explain the bill as opposed to having it read.
Are there objections to allowing the sponsor to explain the amendment in lieu of having it read in full? No objections are heard, and the gentleman is recognized.
Thank you, Mr. Speaker. This amendment may be seen as an anti-vaccine amendment. It is not. It is instead an amendment that secures and recognizes our religious freedoms, not only in the concept of other areas that this legislature has rightfully attached religious freedom and recognized it, but also with respect to our children, their attendance to school, and their ability to associate with other children despite what religious observances and objections their parents may have. And so this amendment simply says that notwithstanding any other provision within this code,
This section shall not apply to any child whose parents or guardians present a letter stating that a child cannot be vaccinated for religious reasons, and an exemption from the requirements of this section shall be granted. That letter would be given to the principal or the state-funded daycare provider. Thank you, Mr. Speaker.
You've heard the amendment explained. The question now is, shall the amendment be adopted? Is there debate on the amendment? Gentleman from the 54th, Douglas Pushkin's recognized.
Thank you, Mr. Speaker. Would the sponsor of the amendment yield?
Yes, sir.
Quick question. What religion in particular prohibits the use of vaccines?
There's actually several. One of the more prevalent within this state would be the Catholic religion that has objections, some of its observers, with respect to the utilization of embryonic and fetal cells from elective abortions.
Well, those aren't used in vaccines. I would like to see, evidence of that that's actually used in a vaccine. I've not heard of any real prohibitions within the Catholic Church to these types of vaccines.
So to answer your question, this is coming from the National Institute of Health, and it finishes my sentence by saying that the use of embryonic and fetal cells from elective abortions in the pharmaceutical industry, including vaccines and medical research, is commonplace.
Is what?
Is commonplace.
Okay, well, I'm going to look that up, and maybe I'll ask you some questions later, but I've never heard of that. I've never heard of any real religious prohibitions on vaccines.
Gentleman is finished. Gentleman from the 53rd, Douglas Pritz, recognized. Clerk will please turn on the microphone of the gentleman with 78th, Douglas Shirelli.
Thank you, Mr. Speaker.
Gentleman's recognized.
Thank you, Mr. Speaker. So something that I commonly hear from a lot of the folks that are in opposition to a religious exemption to vaccines is the idea that if we pass this, there's going to be death on the streets, there's going to be mass hospitalizations, that the sky is falling. But that's just not the case. There are 45 states, 45, that offer more protections, that provide a religious exemption to vaccinations. 45 states. Such conservative states as Washington, D.C., the state of Washington, Massachusetts, Vermont. 45 other states provide more protections for religious liberties than the state of West Virginia. So that has to be put in perspective here. What we're doing with this amendment, this is a very, very good amendment. And I appreciate the gentleman from the 44th from having the courage to put this forth. Okay, we need to protect religious liberties in our state. I mean, look at where we vote nationally in terms of Republican politics. Not to get too political on this, but if you look at where we are politically and where the people are, the people of West Virginia, Mountaineers are always free. Mountaineers are always free when it comes to religious liberties. It's not necessarily my religion or the religion of probably a lot of the people in this room, but it's some people's religion that they have an objection to this. And people can say, well, you can come up with a religious objection for just about anything, and you can go down that path of everything possibly being acceptable. And I think on some level we do have to apply strict scrutiny when it comes to this sort of thing, and we need to look at what other states are doing. West Virginia is out of the mainstream when it comes to religious exemptions. We are. We are at the bottom when it comes to protecting religious liberties because we have this on the books, because we're not protecting the religious liberties of people who might have views that are different than us. You might not agree with those views. You might think that those views are out of step. You might think that those views are not what you would do with your own children. But it's a sincerely held belief with many people. All this bill does with this amendment would be to ensure that the religious liberties of all West Virginians are protected, that we do something common sense that's within the mainstream, which is consistent with states that are far more different than us in terms of how they vote nationally on issues. This is a bill that's going to be something that is in the best interest of protecting the religious liberties of all West Virginians. I would urge support and adoption of the amendment. Thank you, Mr. Speaker.
Lady from the 81st, Doug Hamilton, is recognized.
Thank you, Mr. Speaker. A lot of times when we talk about religious exemptions, we're talking about a classified group of people who I have not heard anyone say any documentation from, if it's the Catholic Church, from their priest, from their pope. So this would just be parents saying that, and we don't know if they are practicing this religion, if they're making it up. There's no documentation. One thing that we do very well, seemingly, is that we do not follow data. The one area that we have done well in when it comes to health is in the area of school vaccines. We cannot compare ourselves to other states. Why? Because we're the highest in obesity, we're the highest in hypertension, we're the highest in diabetes, our kids are dying by suicide, so we cannot compare when we are the highest in everything that makes our health poor. What we're going to do, no, I don't believe that we're going to see more deaths, but what I do believe is we're going to see more hospitalizations, which is more money, which can ultimately lead to more deaths. We're talking about diseases that are debilitating. So you want to remove vaccines in order for kids to be able to play basketball. They're not going to be playing basketball if they are disabled by some of these vaccines that we have been protected from illnesses that we have not seen. We have been cushioned living in a bubble because we have not experienced some of the debilitating effects of these illnesses which was the reason why the government moved that we have these vaccines. We can say it's under religion, we can say it's under medical, but what we're doing is open up Pandora's box to illnesses that we do not know of. We watched what certain illnesses have done in the last 3 years. That will happen because overall West Virginia is not healthy. Physically, mentally, socially, we are not healthy. So it becomes our job and our duty to put forth legislation that is going to protect the minority, and that changes depending upon what we're talking about. It is our duty to protect West Virginia, who are most vulnerable, and from data standpoint, not personal standpoint. You're not going to hear this in church. You're going to hear this from every medical doctor. We are most vulnerable when it comes to our health. So we have to put forth legislation that is going to protect the most vulnerable. It may not be some of us in here. We may be healthy, but what about those that don't have access to health care? Those that don't have the money, the transportation, those that don't have access. We have maternal deserts, we have food deserts, and we have the audacity to be talking about removing vaccinations. We must do better. And for that reason, I reject the amendment, and hopefully everyone else can see the reasoning according to data and not just by opinion. Thank you, Mr. Speaker.
Gentleman from the 42nd, Doug Steele, is recognized.
Thank you, Mr. Speaker. Wow. You know, no, I'm not a medical doctor. I am a lawyer, and I don't just play one on TV. And one of the things that Constitution of ours does say is that every child in this state has a right to a free and public education, regardless of their vaccination status. But we don't provide that to them. We don't provide that to them at all. As a matter of fact, we try to paint a circle around them like we're living in the book of Leviticus or Numbers or something, and call them unclean and put them out the camp. Don't get to participate in our co-curricular activities if you don't take this vaccine. And talking about the safety of these vaccines, you know, I just had the opportunity to visit our neighboring state of Virginia last weekend, and I tell you what I didn't see is hospitals full of kids with measles and mumps. Hospitals full of, or kids laying in the street stricken with polio, right? Or Kentucky, or Pennsylvania, or all the other states around us, the 45 states that, as my friend from the 53rd described, you know, those crazy right-wing conservatives up in New York with their religious exemptions for vaccines and everything else. We don't see the problems there. You know, what we do have a problem with, for some reason, is accepting religious freedom here in this state. And I would say that it is a part of every major world religion to not ingest the blood of an unborn dead child into your body. And it is a proven fact. It is a fact. It is a medical fact. It comes from these fantastic pharmaceutical companies that some of us in here love so much, that they have admitted that they developed these vaccines from aborted fetal tissue. That is offensive to every major world religion, not just Christians, not Church of God, not Baptists, not Methodists, not just Jews, not just Muslims, not just Hindus, not just Buddhists, not just Taoists. I can think of no major world religion that doesn't find that offensive to their doctrine. And we had such a fight last year with the Religious Freedom Restoration Act. And this very issue came up. This very issue came up in this debate was, would that somehow allow for a religious exemption here with our vaccine mandates? Because I think all of us in here acknowledge that we are the outlier. We are the outlier. And of course, that's not been brought up in court yet. I believe there was a case up in the Northern District in federal court that was dismissed, but it's not been challenged in state court. But what we have today is a challenge in front of us to do the right thing, to provide that religious freedom, regardless of what your doctrine is, whether it be Christian, Muslim, Hindu, Jew, whatever the case might be, that if this offends your religion, that you can let the school know that you take a firm stance on your religion, and that be that. Now, the gentlelady talked about, well, you know, a parent could just write something down and send it into the school. Absolutely. You want to know why? Because there's another part of that Constitution that, thank God, lawyers were writing, and not medical doctors 250 years ago, that says no religious test will be required. Because I'll tell you, when lawyers were writing that down, medical doctors were letting out blood and putting leeches on us when we were coming up with that Bill of Rights. The things that we defend and keep us free. But West Virginia's not free today, at least not our kids, unless we want to pump them full of heavy metals and aborted fetal tissue. Then they can be free. But are we really a free people? And I think that's what the gentleman's amendment basically gets to. Do we cherish religious freedom? Yes, we passed that bill last year. Do we cherish the part of our Constitution that says that every child has a right to a free and public education? Yes, we've affirmed that on many occasions. Well, let's marry the two up right now. Let's just marry the two up right now. Because we've all passed it before in some form or fashion or another. Let's finally get in here on the floor. I've been here 6 years. This is the first time I've got to take a floor vote on this. First time. And I hope it'll be the only time that's necessary that we take this vote. And I know what somebody after me is going to get up and say. What will the Senate do? I've heard stories coming out of the Senate for the last couple days that boggle my mind about what they're doing over there. The only thing I know I can do right now is to do what's in front of me. That's the right thing for the people of West Virginia, and that's the right thing for freedom, and that's the right thing for religious freedom, and that's what I told people I'd come up here and do, and that's what most of you told people you would come up here and do, is vote to defend their rights and religious freedoms. And not use all these scare tactics. This mumbo-jumbo coming from a pharmaceutical industry that can tell you whatever they want, and they have immunity for lying to you, and you can't sue them if they hurt you. And that's somehow factual, what they're telling us, the science. They can make it up as they go along. They have made it up as they go along. These are the same people that told you to smoke Cools. Your doctor recommended it. But what this is about today is someone's individual right to say, as for me and my house, we will serve the Lord of our choice, and we will abide by that doctrine. It's not about the science of it. It's about your right. And I'm here to defend that right, and I hope you are too, and I hope you support the gentleman's amendment.
Gentleman from the 27th, Griffith, is recognized.
Thank you, Mr. Speaker. Why aren't there kids lying in the street dying with polio, measles, and other diseases? Well, in 1776, the life expectancy in this country excuse me, was 35. In 1900, it was 47. In 1950, it was 68. In 2019, it was 79. And then it went down for two things: COVID and the opioids. Religious exemption, I don't remember that ever being talked about with vaccines in my entire lifetime, but I do remember my classmate with polio. I do remember 1.1 million people dying of COVID, and as the gentleman pointed out, we've had some people die of vaccines. With COVID, they can't determine for sure, but they think around 5,000 people died from the vaccine to allergic reactions. 1.1 million people died without it. This, to me, is not about religious freedom. It's about us doing something that children can't make a decision about. And so we're going to let parents make a decision when the state has decided, let's keep raising that life expectancy. These diseases are coming back. Measles is in every state around us. And think what that does to the immunocompromised and the elderly. Whooping cough can kill an elderly person. So that's why I'm for this. And that's why I'm against this amendment, because I want us to continue to protect our children. And I can't imagine living in 1776 when we got our freedoms, that it was most likely I wasn't going to live past 35. But please consider this. We're making important decisions here, and I get the arguments on both sides. But for me, I'm going to go with science and the data that shows that we can make West Virginians healthier. Thank you, Mr. Speaker.
Gentleman from the 76th, Garcia, is recognized.
Thank you, Mr. Speaker. So with our immunization laws, we're actually in the top of the states as far as how many people are immunized and how that protects our children and protects our people, our vulnerable people. I don't know, sometimes it feels like we're not used to being in the top 5 or 10, and maybe we just want to get out of that lane. But, you know, polio is a real thing. Some of these other vaccinations, I mean, these are real things, and it's amazing how quickly we forget history. It's amazing how quickly we forget our history. But to the gentleman from the 42nd's point about RFRA, we had a full and fair debate, and it was put forth that that did not apply. And certainly courts could say something different, but everybody was under the understanding in this legislature that that bill did not apply to vaccinations. And this body voted on that and passed that bill as such when it had the opportunity to make those changes. And so right now, again, the bill as it was introduced, I see that as like with this wall of protection, that was a crack. The bill is amended, it's like we're taking a sledgehammer, and this amendment right here, we're taking a bulldozer to try to break that wall down. And I don't think that's the right thing to do. So I oppose the amendment.
From the 93rd, Hornby is recognized.
Thank you, Mr. Speaker. Would the gentleman from the 44th yield?
Sir.
Gentleman does yield.
Am I correct in reading this that if your amendment passes, this would be a religious exemption across all schools, public schools?
Yes, sir.
Thank you. Mr. Speaker.
Is the gentleman finished with
yes.
posing questions? Okay. The gentleman's recognized to speak to the amendment.
Speak to the amendment. I've been a Rotarian for a long time, and I've been fighting the fight for polio for a long time. I grew up in a third world country, and I've seen polio firsthand. We are extremely close to eradicating the second disease ever. We've done it for smallpox. With global travel the way it is, and the recent outbreaks of measles in states and polio in other states, I don't think this is the right time to not vaccinate our kids. West Virginia leads the nation in our vaccination policies. We are not a very healthy society. We also lead the nation in unhealthy policies. I can't vote for this amendment. Thank you, Mr. Speaker.
The question still is on the primary amendment. Gentleman from the 17th Delegate Penson is recognized.
Thank you, Mr. Speaker. Friends, I know the day's gotten long, and I know we're tired in here. We've been deliberating on a multitude of issues, but pay close attention right here, because this amendment is absolutely about religious freedom. Don't take the light off the fact that this is a religious freedom choice. It's not about how you feel about vaccines. With all due respect, how you feel about vaccines shouldn't cross the street and be applied to your neighbor. It's been said in here today that it's our responsibility to make this decision for these school children. It's been said in here today that it's the school district's responsibility to make these decisions for their children. It is not. It is their parents' decision to raise their children and to choose to allow their children to have vaccines or to choose to refrain from having these vaccines. Now, just in case you're wondering, all of our children, and that's a lot, by the way, all of our children are fully vaccinated. I'm not anti-vax. Our children have had every vaccine offered to them. My wife and I are perfectly okay with that. But you and your spouse may not be. It's been said that we lead the nation in vaccine percentage because we've been forcing kids to take it. It's no wonder we lead the nation. Friends, I would submit to you to consider what you're getting ready to do. This amendment is not about how you feel about vaccines. This amendment is how you feel about the First Amendment to our Constitution, how you feel about religious liberty. Thank you, Mr. Speaker.
Question still is on the primary amendment. Is there other debate on the primary amendment before the chair recognizes the sponsor? Gentleman from the 79th Delegate Hansen is recognized.
Thank you, Mr. Speaker. I'm thinking about the arguments for freedom, and there's lots of things parents have the freedom to do, as they should, but there's something a little bit different about vaccines. The reason why we have the law as we have it, which is that vaccines only provide the public health protection if most people are vaccinated. I mean, there's a difference. There's a reason why we have that restriction, that requirement in state code in order for vaccines to work. You're not just protecting your child by deciding to have them vaccinated. You're protecting your neighbors. You're protecting your grandparents. You're protecting other kids that are immunocompromised and not able to take a vaccine. So there's a reason. And what we know from other states is that when people choose not to be vaccinated, there are outbreaks. In Ohio, just in the last year or two, there was a measles outbreak, 85 kids with measles, virtually all of them unvaccinated. Go back a couple years before that in New York State, There was about 1,000 measles cases. They were centered in the Orthodox Jewish community, people who decided not to get vaccinated for religious reasons. There's an outbreak of about 1,000. So what we do know is that when we crack this door open and fewer people get vaccinated, there will be more and more outbreaks. That's just going to happen. That's the way it works. Because vaccines actually do work. The ones that we're talking about today that are in state code, we have decades of data demonstrating that they work, they're safe, and they're effective.
Gentleman from the 69th Delegate Marple is recognized.
Thank you, thank you, Mr. Chairman. I'm going to make this short and sweet. I can remember when the first polio vaccine came around. It was on a sugar cube. They put us on a bus, took us into Clarksburg, and we all got our sugar cube. I don't know how many of you have ever seen an iron lung, but there were lots of iron lungs around in the 1930s, 1940s, 1950s. These were kids that had polio and couldn't breathe. I've had the measles, the little measles, the red measles, the big measles. I've had the mumps. I've had the chicken pox. But they have vaccinations for those today. You hardly ever hear of a kid getting them. Now, they reported a month or so ago they found the polio vaccine in the sewers in New York City. We've got a danger in this country. There's over 10 million people have slipped across the border, and not a one of them have been tested, not a one of them have been vaccinated by the government. And they're loose in this country, and they're carrying all kinds of diseases. I was told by my grandparents that an ounce of prevention is worth a pound of cure. If you want to protect your children, see that they get vaccinated. I'm voting against this amendment, and I do not support the bill in its entirety either. Thank you, Mr. Chairman.
For what purpose does the gentleman from the 54th Delegate Pushkin seek recognition?
Thank you, Mr. Speaker. Before I ask the gentleman to yield, I didn't speak to the bill.
Understood. The gentleman is recognized then to speak on the amendment.
Thank you, Mr. Speaker, and I'll keep it brief. Yeah, as one of the few members, practicing members of a religious minority in this body, really one of the few members of a religious minority in this state, First Amendment and the freedom of religion is very, very important to me. So I've done a lot of, I've asked a lot of questions outside of this because I knew things like this would be coming up. And I can't find any official statement from any church, synagogue, mosque in opposition to vaccines. I looked up what I could find from the Catholic Church. I believe it goes back to 2017 Pontifical Academy for Life released a statement. We believe that all clinically recommended vaccinations can be used with a clear conscience, and that the use of such vaccines does not signify some sort of cooperation with voluntary abortion. While the commitment to ensuring that every vaccine has no connection in its preparation to any material of originating from an abortion. The moral responsibility to vaccinate, let me repeat this part, the moral responsibility to vaccinate is reiterated in order to avoid serious health risks for children and the general population. I've asked the same of my rabbi. Do we have any objections to vaccinations in our religion? No. No. Like all religions, we're for protecting life, doing no harm, and doing the best we can for the general welfare, and that means stopping the spread of communicable diseases that we've done a relatively good job of in this state thus far, until y'all get a hold of it.
Gentleman from the 11th, like Fehrenbacher is recognized.
Thank you, Mr. Speaker. I'd like to speak to the amendment.
Yes, gentleman is recognized.
Fellow delegates, of the 400 to 500 votes that I have cast in this body on this floor, this is the one that has troubled me the most, because I understand and I respect the various perspectives that have been voiced. I fully respect and honor the right for religious freedom. But, as my fellow delegate from the 54th just cited, as a Catholic, it was my understanding that my religion does not preclude me, nor my children, nor my grandchildren from being vaccinated. The 10 diseases that are prescribed in West Virginia Code that school children must take, 9 of the 10, by my research, are infectious. They're contagious. They can be passed on from child to child. With this amendment, we are potentially opening the door to 250,000 children to avoid vaccination. Now, I realize they're not all going to all of a sudden stop or not be vaccinated, but there's 20 or 25,000 that are going to enter that possibility every year. And as I contemplate that and the consequences of some of these diseases making inroads, I am troubled. Some of these diseases will run their course, and there are treatments and medicines that a child can recover from. But then there are others, like meningitis. There is no cure. If you got it, you're going to suffer the consequences. There are others where you may contact it, like rubella, German measles. If a female contracts that, you may pass that on as a pregnant woman to your child. So potentially we're talking about children or grandchildren or great-grandchildren passing on congenital rubella syndrome as an example, where children with that disease can suffer hearing impairments, eye and heart defects, and other lifelong disabilities, including autism, diabetes, and thyroid dysfunction. With that in mind, as much as this may sound like taking away religious choice, I have decided that I cannot support the adoption of this amendment, and I would encourage you to think about the long-term consequences of voting and opening the door and what that may mean, not just now, but generations to come. Thank you.
Gentleman from the 55th, Douglas Akers, is recognized.
Thank you, Mr. Speaker. Let's keep in mind that today we're voting on one thing only on this amendment, and that's a religious exemption, of which it is factually true that 45 other states allow it. Multiple other states also allow, I think 15 allow for just any personal objection whatsoever. It doesn't even have to be a religious objection. And I believe we're one of 3 states that only allow for a medical objection. Like our good friend from the 17th, all of my kids are vaccinated. They've received all of their recommended vaccinations, all of them. But it is also true, factually, what the gentleman from the 42nd said when he referenced aborted fetal cells being used to develop vaccines. That is a scientific fact. And this is just one website where you can go. There's many others. You can look on your phone right now while I'm talking and fact check me, and you're going to see that I'm correct. This is from the North Dakota health site. I'm reading verbatim. Why are fetal cells used to make vaccines? Historical fetal cell lines were derived in the 1960s and 1970s from 2 elective abortions and have been used to create vaccines for diseases such as hepatitis A, rubella, and rabies. Abortions from which fetal cells were obtained were elective and were not done for the purpose of vaccine development. The fetal lines being used to test or manufacture the COVID-19 vaccines are from 2 sources, and it goes on to list the sources. So it is simply scientifically and factually true that there are fetal cell lines being used to manufacture vaccines. There are people who sincerely, religiously object to that. Again, I say that as a parent who's had my children vaccinated. I have no idea where the source of those vaccines came from, but that's the choice that we made. Today's vote is only on religious exemptions. That's it. The vote on the rest of the bill is for another day. And I'll tell you that my vote on that may be different when it comes to in-person attendance at schools. I'm just being honest with everyone in this room. But when it comes to religious exemption, we're one of the only states in the country that does not allow it. And we don't see outbreaks of diseases in those other states. That is also factually true. So I'm just talking about the facts here today. The number of states that allow it, and the fact that these vaccines, many of them are derived from fetal cells, for which many people hold a sincere religious objection. And I respect that.
Gentleman from the 23rd, Worrell's recognized.
Thank you, Mr. Speaker. Would the gentleman from the 93rd yield for a question? You yield for a question, sir.
Yes, gentleman does yield for a question.
Yes.
I know you referenced where you grew up, but I'd
Yes.
like to ask you, how many polio cases are there in the U.S.? Do you know?
How many active polio cases?
Yeah.
I don't know the answer to that.
Zero would be the answer, and has been.
No, there's been 15 this year.
No, there have not. Not in the U.S. There have not. There was one in 2022, but there are zero in the U.S.
There are still cases in the U.S. derived from the vaccine, believe it or
Not
not.
according to the CDC's website.
It's not the information I have.
Now, I would say your information is wrong. Thank you, sir. Appreciate it. Will the gentleman from the 79th yield for a question?
Yes.
Thank you, sir. Respectfully, I know you referenced the 85 cases in Ohio for measles, correct? That was in 2022. Do you happen to know how many cases of measles in the entire country there were in 2023?
No.
There were 58 total cases in all of 2023. I know we had an outbreak there in Ohio, right, in 2022 of 85 cases, but there were 58 in 23. I just wanted to reference that. I appreciate you answering my question.
And you've probably looked up the numbers year by year, so you've seen there's differences year by year, including how many were in 2019.
Correct. Yeah, you're right. There were some cycled outbreaks there in certain areas in different years. You're correct. Yes. There's 20 this year. I think there's 20 total this year.
Over 1,000 in 2019, right?
1,274 to be exact. Yeah, that's right. Out of 300 million people. Yes, sir. Thank you. I appreciate it for yielding. Mr. Speaker, I speak to the amendment.
Gentleman is recognized.
Ladies and gentlemen, on the religious exemptions, as you've heard many people say, we have 45 states, and we're just saying we want to be the 46th state. I know we've referenced all the surrounding states and all the scares that have been told. In Kentucky, there are 1.7% of exemptions exist in Kentucky. In Maryland, 1.9. Ohio, 3.8. Pennsylvania, 3.8. Virginia, 2.2. The point I'm trying to make here, by allowing religious exemptions in West Virginia doesn't mean that the entire population is going to go out and stop getting vaccinated. You've heard many individuals here that would vote in favor of this amendment say their children are vaccinated. We're not opening Pandora's box here. I know the delegate from the 11th tried to scare you with some crazy story there. But I would attest to you that if that were the case, that would happen in 45 other states. Right? Where is it in all 45 states? Because that's my argument today. There are measles outbreaks in our surrounding states. Where are they in all 45 states? Because that's the argument here. If there are religious exemptions in 45 states, then name measles outbreaks, name other outbreaks in all 45 states. And if you can't do that, then I would attest there's no problem with us allowing religious exemptions in West Virginia. That's all we're asking for here. And like I said, we're not talking about a large percentage of individuals who are going to go out and no longer vaccinate their children. The choice should be there for religious exemption and be the 46th state. 90% of the United States offer religious exemption, although we don't have outbreaks everywhere. So I would ask you all to think about that, and I would urge its adoption. Thank you, Mr. Speaker.
Gentleman from the 47th, Longenegger's recognized.
Thank you, Mr. Speaker. The gentlelady from the 81st brought up a real good point earlier. I don't know if some of you were paying attention when she said it. She said West Virginia is a very sick state. Lots of illnesses in West Virginia. So, you know, that got my attention when she said that, and I appreciate her bringing that up. So I went and looked up CDC stuff, and and I found that West Virginia is number 12 in the nation for child sickness. Number 12. It's awful. So she nailed it. We're also among one of the most vaccinated states per capita. I'll say that again. We're among one of the most vaccinated states in America, yet we have some of the most sick children in the nation. Number 5 in the nation. Who's number 1 for healthy children? Massachusetts. Number 1 state in the nation for healthy kids. And oh, by the way, they offer a religious exemption. Support this amendment. Thank you, Mr. Speaker.
Gentleman from the 100th, right now is recognized.
Would the sponsor?
Yes, gentleman does
sponsor
you. Gentleman does you.
Question. Would it surprise you if you knew that I had been married to a Buddhist for 36 years?
No, you have a Buddhist temperament, so that would not surprise me.
And would it also surprise you that I've been around Buddhists for over 40 years now?
In truth, yes, that would surprise me, yes.
Good. I would hope it wouldn't. Would you be surprised that one of the tenets of Buddhism is the preservation of life at all costs?
I'm sorry?
That one of the tenets of Buddhism is the preservation of life at all costs, if you understand anything about Buddha and Buddhism.
That would make sense.
Yes, okay. And would you then be surprised that Buddhists would object to any type of fetal tissue or other body parts being put into their bodies as part of an immunization process?
No, that also makes sense.
Okay, so you wouldn't be surprised about that?
Not surprised.
Okay, very good. I'm very happy for you. And would you then be surprised that the conservative bastions of California and New York are considering adopting West Virginia's immunization policy because it is in fact so restrictive? Would that surprise you?
No, I believe that is true.
Okay, very good. Thank you very much. Thank you, Mr. Speaker.
Is there other debate on the primary amendment? Gentleman from the 14th, Delegate Foggins recognized.
Thank you, Mr. Speaker. I've heard it said it's better to sit and look like a fool than open your mouth and sound like one, but here goes. It seems like vaccines and mandated COVID shots got pretty confusing there a few years ago. I didn't have very many constituents tell me to come down here and make sure vaccine mandates were enforced, but I had many ask me the opposite.
Do you want to state the point?
There's nothing in the bill or the amendment about vaccine mandates.
While that is true, I think the gentleman was prefacing his debate.
Yes, sir.
Okay, and in light of that, gentleman is recognized to continue.
Thank you. I appreciate you, brother. My niece was made sick by several required vaccines. She was made very sick. And she wouldn't be able to attend a public school. What about her being left out? Her parents decided it's best that they leave our state. That's okay. I get to see them on Facebook, though. I appreciate my friend's amendment, a religious exemption. When my kids were little, there's nothing more precious to me than my children, my kids. I love them. And I would never harm them or wish them harm. When they were little, they'd do things, and I'd say, hey, don't do that. They would say, why? I would say, because I said so. I appreciate the religious exemption. It's a step in the right direction. But why can't it just be because I said so? These are my children. My doctor advises me not to do this to my children. Why can't it be because I said so? It's pretty simple. Thank you, Delegate, for the amendment. I appreciate you.
Question remains on the primary amendment. Is there other debate on the primary amendment? Gentleman from the 36th, Delegate Green is recognized.
Thank you, Mr. Speaker. I concur with the delegate from the 14th. Being the newest delegate here, I have great desire not to be standing up right now, but I also feel very urgent to be able to say this before all of you. Before I came here, I felt religious freedoms was something that was very, very important to all of us. Whether we think that vaccines are correct or not, whether your religion accepts it or doesn't accept it,
The bottom line is, it's religious freedom. It's the First Amendment. I appreciate the delegate from the 44th Amendment, and I urge passage.
Is there other debate on the primary amendment? Chair will recognize now the sponsor, gentleman from the 44th, to close debate on the primary amendment.
Thank you, Mr. Speaker. I wholeheartedly appreciate all of the debate that we've had here. I don't agree with some of it, but I do appreciate the fact that we've taken the time to work through this because it is very important. I do want to reiterate a point that I made earlier and that's been made several times since. This is not about whether or not you like vaccines or do not like vaccines. I went through public school. My parents were both public school teachers. I don't think they thought twice about it. My wife's a public school teacher. My children are fully vaccinated. But for the people across our state who hold a religious belief that causes them to have an objection to these vaccines, this is the fair way to do these people, to apply the U.S. Constitution and the West Virginia Constitution to them equally. So some statistics before I get into the Constitution. You know, it was brought up that if we don't do this, then our children will suffer. There'll be a huge drop-off in immunization. Massachusetts, the conservative bastion of Massachusetts, does not have a vaccine mandate, but they have 96.2% immunization for their children. Maine, to the north of them, does have a mandate that does not allow for a religious exemption, 96.7. 0.5 of a percentage point is the only difference. And we heard from the delegate from the 41st, that 42nd, excuse me, that Massachusetts has the #1 child health. So the parents in Massachusetts were given the right to make the decision upon themselves, including whether or not they have a religious exception or objection to vaccines, and they obviously have made the right choice. I feel no differently about the parents across West Virginia. If we pass this amendment today and pass the gentlelady's bill on Monday, we will be sending a message across the Mountain State that we believe in parents, and more importantly, or as importantly, we believe in the Constitution and the right to religious freedom. I have great respect for every one of my colleagues in here. I truly do. But it bothers me to my core, as an attorney, as a father, as a delegate, when a sentence starts out with, I appreciate religious freedom, but. Thank goodness our framers and our founders did not put buts behind our Article 1 and Article 2s, Amendment 1, Amendment 2s. They're absolute, and they should be given substantial weight. As much respect as I have for my friend from the 76th, I will correct him on one thing. I don't believe we were all in agreement that the Religious Freedom and Restoration Act did not apply to vaccines. I think it does apply to vaccines. And I think that the way it applies is that is there a compelling interest for our state to encourage children to be immunized? Absolutely. I don't think anybody in here with a straight face could tell you otherwise. But should that interest be narrowly tailored to complete that objective? Yes. According to the Constitution and 45 other states, it should be. This is how we narrowly tailor this bill to put it in line with our Constitution, both here in the state and nationally. I know this is a tough vote for everyone here, and quite honestly, I had a lot of reservations about bringing this bill forward, but I could not agree with the gentleman from the 42nd anymore when he said that all we can do right here and right now is what's before us. All I can do is what's best for my constituents and what I believe as an attorney the Constitution and my Creator require me to do, and that is to give every West Virginian family across this state the freedom to choose based on their religion, their relationship with their Creator, whether or not immunization is right for their children. There was discussion earlier, and I guess the gentlelady from the 81st doesn't know me very well because she said she couldn't believe I had the audacity. The audacity that I have this morning or this afternoon is to just simply recognize an inalienable right that has been here before our country was created and was simply enshrined in our Constitution. Do not get it twisted. The right and the freedom of religion did not come from man. It did not come from a government. It didn't come from a piece of paper. It came from our Creator. All my amendment simply does is recognize that right. This is not radical. This isn't extreme. And it's not anti-vaccine. Like I said, I believe in the science, but I also believe in the Constitution of the greatest country on earth. And it gives every family in 45 states the right to make the decision of what's best for them and their family, except the mountain state, where mountaineers are always free. Hopefully, if this amendment to the gentlelady's bill passes today, we will be even freer. Please support the amendment.
Debate on the primary amendment has been closed. The question now is, shall the amendment be adopted? Roll call votes demanded. Is the demand sustained? Demand is sustained. Question again is, shall the amendment be adopted? The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 58 ayes, 37 nays, 5 members absent, a majority of members voting in the affirmative. The chair declares the amendment adopted. Clerk will please report the next primary amendment.
Delegate Pushkin moves to amend the bill on page 1 by striking out everything after the enacting clause and inserting in lieu thereof the following. This is HFA Pushkin 2-23.
Ladies and gentlemen, this is a comprehensive strike and insert amendment, as is our usual practice. We've processed now all of the pending primary amendments. This is the most comprehensive of the primary amendments. If enacted, it would become the bill. Shall recognize the gentleman from the 54th, Delegate Pushkin, to explain the amendment.
Thank you, Mr. Speaker. I believe I could explain it a lot quicker than we could have it read, and I'm not going to belabor the point here. This amendment returns us to the bill that came out of the House Committee on Health and Human Resources, a bill that was voted on by 1/4 of this body, restores the work of the committee, and on that bill, it provides an exemption for students that are in virtual schools, but keeps the exemption but except for the children to participate in public school extracurricular and co-curricular activities. It adds that back in there, but it just applies to students that are in virtual charter schools. I think I know how this is going to go, but I'm going to reserve the right to close.
You've heard the amendment explained. The question now before the House is, shall the amendment be adopted? Is there debate on the amendment? Gentleman from the 55th, Delegate Akers, recognized.
Will the gentleman yield for a question?
Yes.
The gentleman does yield.
Would you be willing to reform your amendment to add the religious exemption that we just voted on?
No.
Thank you, sir.
Question still is on the primary amendment. Is there other debate? Is there further debate on the primary amendment? If not, Chair will recognize the sponsor to close debate on the primary amendment. Gentleman from the 54th, Delegate Pushkin, is recognized.
Yes, thank you. Like I said, I think I know how this is going to go. I would say that, if you had declaring war on Jonas Salk and Louis Pasteur on your legislative bingo card this year, I guess you win. However, the children of West Virginia lose.
But gentlemen will state the point.
Thank you, Mr. Speaker. He's talking about Louis Pasteur and different people. He's not really speaking to the amendment, I don't think.
Gentleman gave some latitude to you, sir. We'll give a little latitude to the gentleman as he closes debate.
Well, Louis Pasteur is well known for the pasteurization of milk. His work also led to the advent of vaccines.
Chair will ask all members to confine remarks closely to the amendment, but gentleman is recognized to close debate on the amendment.
All right. Thank you. I was stating that while Louis Pasteur is best known for the pasteurization of milk, his work also did lead to the advent of vaccines, which have been proven to be effective in curtailing and in some cases eradicating many communicable diseases that we're about to go backwards on right now. I was unaware that making America great again meant a return to the 1800s, but I guess that's where we are.
The debate on the amendment has been closed. Question is, shall the amendment be adopted? Those in favor of adoption of the amendment will please say aye. Those opposed will please say no. Noes appear to have it. Noes have it. Chair declares the amendment lost. Are there other amendments to the bill? If not, the bill will be advanced to third reading. Clerk will please report the next bill on second reading.
Committee substitute for House Bill 5162.
Lady from 71st.
Thank you, Mr. Speaker. I move that we postpone action one day.
Lady from 71st asked unanimous consent to postpone action one day on the bill. Are there objections heard? No objections are heard. Action will be postponed one day on the bill. Next bill on second reading.
Committee substitute for House Bill 5254 relating generally to the creation of mental hygiene regions by the Supreme Court of Appeals.
Are there amendments?
Delegate Lewis moves to amend the bill.
Does the gentleman wish to explain the amendment in lieu of having it read in full? Are there objections? No objections are heard, and the gentleman is recognized to explain the amendment rather than in lieu of having it read in full. Gentleman from 57, Delegate Lewis.
Thank you, Mr. Speaker. Basically, the amendment strikes the requirement that a mental hygiene commissioner would need to be an attorney. I think, again, while I respect, definitely I have a law degree, so I respect the profession. I don't know if attorneys alone or to themselves are, just the best to work this position. I think we have psychologists, those who work in behavioral health, and a multitude of others who would be adequately serving this position. In addition, when we talk about involuntary hospitalization or incarceration, we have magistrates who aren't attorneys. We have parole board members who aren't attorneys. So I think what I would like to see is that the field be expanded, and particularly be expanded to those who are experts in the way of behavioral health. So that's the amendment.
You've heard the amendment explained. The question now is, shall the amendment be adopted? Is there debate on the amendment? Lady from the 73rd, Douglas Summers, recognized.
Thank you, Mr. Speaker. As part of our ongoing efforts over the last 3 years to work on the mental hygiene process, our interim committee on joint health, in conjunction with the West Virginia Supreme Court, developed this bill and determined that an attorney was best suited for the role of mental hygiene commissioner. This person makes the decision to take away your liberties. I think it needs to be an attorney. I urge rejection.
Gentleman to 42nd, Douglas Steele.
As a former mental hygiene commissioner, I find this amendment extremely alarming. A mental hygiene commissioner actually conducts a hearing in which they receive expert testimony under the rules of evidence of West Virginia. And it's unique for an attorney to be versed in that. I mean, that's a mandatory class that we have to take in law schools, typically the second year of law school. The rules of evidence are actually tested on the West Virginia bar exam as well. And when you're talking about a person's liberties, we're not just talking about confining them. We're talking about taking away their firearms rights. We're talking about taking away their right to control their own money, the right to control their own property, of whether or not the state is, through the sheriff's department, is going to be appointed over them. And that testimony is largely based off an evaluation from a mental health provider. That mental health provider is subject to examination by the court-appointed counsel to the person who's brought in on a mental hygiene petition. To me, taking away the requirement to have a member of the bar, a licensed attorney in this state, to determine such a broad range of things that can happen to an individual that in many cases are permanent deprivation of life, or not necessarily life, but at least of liberty and property. I would hate to see us take a step backward with this. I mean, it makes absolutely no sense whatsoever, I have to urge rejection of the amendment.
Is there debate on the amendment before the chair recognizes the sponsor? No further debate is heard. Chair will recognize the sponsor, gentleman from 57th, Douglas Lewis, to close debate on the amendment.
Thank you, Mr. Speaker. When we talk about, taking people's rights away, when we talk about incarcerating people, involuntary hospitalizations, the first point of contact to the criminal justice system is the magistrate. I was a magistrate. I am not a barred attorney. I have a law degree, but I'm not barred. We take away people's rights. We fine people. We would, determine whether you're going to be evicted or not. You don't need to be a licensed attorney to be a magistrate. I was on a parole board. We determined whether you're going to be released from incarceration or if you violated the terms, you're going to go back to incarceration. Not an attorney. The magistrate system is literally the ER for the court system. And I don't think that we need to have our mental hygiene as commissioners as attorneys. Again, I'm not even sure attorneys are best suited for this position. I think when we look at it, we can have behavioral health professionals, psychiatrists, psychologists, counselors, even social workers would be more in a better position to determine the specific illness that a person is suffering with and the appropriate remedy for that illness. So for that, I would hope you would support this amendment. I hope we can expand the field of qualified applicants that we could get for our mental health commissioners. Thank you.
Debate on the amendment has been closed. The question now is, shall the amendment be adopted? Roll call is demanded. Is the demand sustained? Demand is sustained. The question is, shall the amendment be adopted? Those in favor of adoption will vote aye. Those opposed will vote no. The clerk will prepare the machine. On the 100th, your vote's not registered. Clerk will close the machine and ascertain the result on this question. There were 11 ayes, 78 nays, 11 members absent. Less than a majority of members having voted in the affirmative, the chair declares that amendment lost. Are there other amendments to the bill? If not, the bill will be advanced to third reading. Next bill on second reading.
Committee substitute for House Bill 5345 relating to the registration requirements in the Sex Offender Registration Act.
Lady from the 71st.
Thank you, Mr. Speaker. I ask unanimous consent that the bill be advanced to third reading with the general right to amend.
Lady from the 71st, ask unanimous consent to advance committee substitute for House Bill 5345 to third reading with the general right to amend. Are there objections? No objections are heard. Bill will be so advanced. Next bill on second reading.
Committee substitute for House Bill 5530 relating to requiring a hospital to disclose price and fee information for certain health care services.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 5539 providing that causes of action under Chapter 46A of the Code of West Virginia survive the death of the party.
Are there amendments? If not, the bill will be advanced.
House Bill 5696 relating to the Upper Ohio Valley Trail Network.
Are there amendments? If not, the bill will be advanced. Are there other bills on second reading today? If not, Lady from the 71st.
Thank you, Mr. Speaker. Subject to announcements, I move that the House stand in recess until 6 p.m.
Are there announcements? Are there announcements? Lady from the 73rd, Delegate Summer. Lady from the 49th, Delegate Tully.
Thank you, Mr. Speaker. Your Committee on Health and Human Resources will meet today, Friday, February 23rd, 30 minutes after the conclusion of floor session in the East Wing Committee Room. Republican members will caucus in the chair's office 15 minutes after the conclusion of floor session today. The agenda is posted. We will consider one bill, and please bring your laptops. Thank you.
Gentleman 97, Douglas Hardy.
Thank you, Mr. Speaker. Your Committee on Finance will meet today, February 23rd at 4:30 p.m. in the Finance Committee Room for a committee meeting. Republican members will caucus at 4:15 in the Finance Committee Room. The agenda is posted. The agenda will be posted. Thank you, Mr. Speaker.
Gentleman the 8th, Delegate Kelly.
Thank you, Mr. Speaker. The House Committee on the Judiciary will meet at 3:40 in the Judiciary Committee Room to finish up our agenda. Also, Mr. Speaker, the committee will meet Monday, February 26th in the committee room at 2:30 p.m. with Republicans meeting in the chairman's office for a caucus at 2. The agenda will be posted.
Gentleman from the 53rd, Douglas Pritt.
Thank you, Mr. Speaker. Your Committee on Government Organization will meet Monday at 1 o'clock p.m. in the Government Organization Committee Room 215E. Republicans will caucus in the chair's office at 12:45. The agenda will be posted.
Gentleman from the 65th, Douglas Martin.
Thank you, Mr. Speaker. Your Committee on Political Subdivisions will meet Monday, 10 a.m. in the House Education Committee Room. Monday, 10 a.m.
Are there further announcements? Are there further announcements? If not, the question's on the motion that the House stand in recess until 6 o'clock. Those in favor will please say aye. Those opposed will please say no. The ayes have it. The motion is adopted. The House is in recess until 6 o'clock.